I did not know. Okay. What's good, everybody? We are back. We're running a little late. We're actually going to look at two different trials today. I got one on pause. I'm going to start with this one here. Let's start with this one. Yeah, let's just get up a little bit into it. I just want to make sure the sound is on. I just got to run a probation. Yeah, I'm sorry.
Letter
There we go.
from a law firm in West Palm
Okay.
Beach dated yesterday. It says that it was sent to,
We are actually going to be covering still the Ashley Benefield trial. And today, we got Christine Ricci starting for a stabbed in the heart murder trial. We're going to cover both of those today. So lock in with me. We're going to rock this bitch.
the state and the defense. Did you each get a
And-
copy, State?
Yes.
You know we gaming.
I did, and I responded late.
You know we gaming.
last evening.
But I'm going to let this rock. I got to run a probation.
As well as
You should
Yes.
be over before I do that.
Oh, I don't have those responses.
He just said, thank you for sending it. I said I didn't get an attachment and realized I was looking at the wrong email.
I thanked him. I told him it was worthy of calling it to the court's attention and that I was confident Your Honor would probably conduct a hearing as a result.
That's what I'm doing. Do you want to be heard on this, State?
No.
Defense? Do you want to be heard on this?
Yes, I'd like the court to question the jurors individually. I don't know, like the lawyer said, whether or not the potential juror heard it. I have every confidence the court can do it delicately and first find out if which juror, if any, was exposed to that, and then find out if they heard anything that had any impact at all upon the perception of the case, and that was extrajudicial in the sense that it was a reference to something that had not been introduced in the court.
All jurors or just male jurors?
Judge, I would suggest respectfully all the jurors, and I think,
Even though the letter says it was a male juror?
yes, because that's what this anonymous source said. But I think to be safe, to the extent there was some jurors in this location, there's limited places to go for lunch around here, Judge, so I think there's potential that there could have been other jurors there as well. And rather than run the risk of not knowing, I think a simple inquiry by Your Honor would put that to rest.
State?
And Judge, I would just recommend that maybe we ask the group these general questions, and if anybody says that they've heard anything or seen any news or heard you talking, then we can talk to them individually, because these people may not have had any information. And then we'll spend time doing an individual on it.
The concern with that is, in my experience, respectfully, any juror that was exposed to that may be very anxious about acknowledging it.
All right, thank you. I'll bring them in individually to ask about that. Of course, we've already discussed Dr. Quintel when we came back from a recess. He was approached by a reporter in the hallway while he was in the middle of testifying, but on a recess, asked if he could be, the reporter asked if he could ask questions of Dr. Quintel. Dr. Quintel said no, and the reporter gave him a card. That's my understanding from Dr. Quintel.
Yes, sir.
Anybody want to be heard on that?
Did not take it, the card.
Do you want to be heard on that?
Sorry, I just wanted to add that Dr.
All right.
Quintel
Do you want to be heard on it, though?
No.
No.
After hours yesterday, I was contacted by Judicial Security and notified that a witness who testified and had not been released from subpoena, and again, this is second or third hand, and it's my understanding both parties have been made aware of this, was being interviewed by a news channel reporter in the hallway outside of the courtroom. When deputies were locking up, someone told them that this was going on. I don't think the deputies actually saw it, but it was reported to them.
And Judge, I spoke to the witness, and there was a discussion with the media, but nothing was talked about what was going on in the trial or testimony or anything like that. And I've spoken with the witness and asked them not to do that anymore before the trial's over.
This is the first I've heard of that, Your Honor. I want to know who the witness was.
The reason I didn't speak in specifics is this is all hearsay within hearsay within hearsay.
I understand.
It was reported that it was Eva Benefield gave an interview to a reporter from News Channel 8.
Give me a moment, Your Honor, please. I believe she's under state subpoena.
Yes.
And did the state request that she remain available under the subpoena?
Yes.
Okay. I think perhaps a hearing may be in order.
All right.
And Judge, I don't know, the state would not be opposed to a hearing. I can represent that this particular witness did not speak about anything that was prohibited by the rule of sequestration. No one said to this witness, you're not allowed to talk to anybody about the case, just your testimony and the witnesses in this trial going on right now. So.
All right. Go ahead.
So, not to compound it, but to the extent we're doing housekeeping things now, we also have an issue, Your Honor, with an impeachment witness to Stephanie Murphy, specifically Faith Brown, who is representing Miss Benefield during the same proceedings. She was not on our witness list, but given the testimony of Miss Murphy, we are going to have her outside this afternoon, and the court may want to conduct a Richardson hearing as to that. So just for planning purposes.
All right. Do you understand that Faith Brown may be called as a witness?
Yes.
All right. I wasn't going to get too involved in the Richardson hearing yet. It needs to be done, obviously, and I've got a note for that. All right. So on the Eva Benefield potential interview with someone at News Channel 8, you're not asking for any relief.
No.
I don't know what relief you're going to ask for, but if you're asking for some relief, I'll let you get started.
Well, the relief I would ask for initially is that she obviously be barred from being called as a witness potentially. Secondarily, to the extent the court admonished her about doing exactly that which she did, I've observed thus far the court's general admonishment that it gives the witnesses.
I appreciate all y'all. Listen,
Well.
appreciate and love all y'all for rocking with your boy. You hear me? Y'all can be anywhere else, but y'all here with your boy AC0315. You know we always live. Love y'all for rocking with it like we're supposed to. You heard? Y'all can be anywhere else. We like 12 hours with AC0315. And always live. Love y'all for rocking with it like we're supposed to. You heard? Y'all can be anywhere else. We like 12 hours with AC0315. And always live. Love y'all for rocking with it like we're supposed to. You heard? Y'all can be anywhere else. We like 12 hours with
This is a young
and
lady who lost her father. I'm not looking to hurt her, but given her disregard for the court's admonition, I'm not looking to hurt her. I think precluding her from being called, given her at minimum court's admonition, whether or not the court feels any further sanctions are as a result of disregard of the court's warnings.
Did you want to be heard at all?
Judge, I would just dispute that she violated exactly the court's order. And if she does testify, Judge, I would just testify that consistently with what she has already testified to in death. And so counsel will know if that changes. But we know what she's going to say. I know she said that has already testified to, so I don't think any potential harm if that changes. But we know what she's going to say.
All right.
Already testified to, so I don't think any potential
Whenever
harm if that changes.
we talk about having a hearing, my assumption at the beginning of that was that it was going to be evidentiary and people were going to call witnesses and present evidence. Here's what the court knows. My someone that was that it was going to be evidentiary told people were going to court call witnesses and present evidence that they observed Eva Benefield giving an interview to News Channel 8 reporter in the hallway outside of courtroom A after court had concluded for the day. Interview to News Channel 8 reporter. At this point, I have no facts or evidence before me. I've got hearsay within hearsay as to something that happened. At this point, I have no facts, so I don't before me. I've got hearsay within hearsay. I gave you that opportunity. That's what I'm saying. Is that if everybody wanted a hearing, then I gave you that. I'm not going to assume that it's true. Is that if everybody wanted a hearing,
I'll be happy to call in and we'll have a brief hearing.
it's up to you. Can you call Ms. Benefield back in? If everybody wanted a hearing,
I'll be happy to call in and we'll have a brief hearing.
it's up to you. Can you call Ms. Benefield back in? State, just looking at the list, you have 3 witnesses left. Do we expect to finish today with the state's case? State, just looking at the list, you have 3 witnesses left. Do we expect to finish today with the state's case? State, just looking at the list, you have 3 witnesses left.
We know the deputies reported the matter, or any of the deputies in the courtroom that saw the conversation with the deputies, what the matter was.
As I said, it was reported to me that some unidentified person told the deputy. As I said, it was reported to me that some unidentified person. Are you the one that they told the deputy? Okay, right here. As I said, Mr. Taylor, it was reported to me that some unidentified person. Are you the one that they told? Apparently, it was reported to Deputy Racky. As I said, Mr. Taylor, it was reported to me. Of course, State. You want to be present? Apparently, it was reported to Deputy Racky. Mr. Taylor. Of course, State. You want to be present? Apparently, it was reported to Deputy Racky. Mr. Taylor. Of course, State. You want to be present? Apparently, it was reported to Deputy Racky. Mr. Taylor. Of course, State. You want to be present? Ms. Benefield, I'll remind you that you are under oath. You can just get a little bit closer to that microphone and just answer the questions in a loud, clear voice. Ms. Benefield, I'll remind you that you are under oath. You can just get a little bit closer to that microphone and just answer the questions in a loud, clear voice.
You appeared yesterday and testified before Judge White in this case, did you not?
I appeared on Tuesday and testified.
Tuesday. You appeared yesterday and testified before Judge White in this case. At the end of your
I appeared
testimony,
on Tuesday and
do you
testified.
recall Judge White instructing you about having contact with anyone at the end of because
On Tuesday and
you
testified.
were to remain under subpoena about having contact with anyone at the end and you were here today because to remain the state requested that you remain as a potential rebuttal witness and
Correct.
you were here today because to remain what did you think Judge White potential rebuttal witness directions
Correct.
to you meant Now,
Well, I was told I wasn't allowed to speak on any of the witnesses in my testimony while in the courtroom.
Now, so,
Well, I was
I'm
told I
sorry,
wasn't
did you
allowed to
finish?
speak on any of the witnesses in my testimony while in the courtroom.
Did you realize that when you decided to have a conversation with the reporter?
I'm finished. Yes, sir.
Did you tell us, if you would, realize that when you decided to have a conversation with the reporter? Tell us, if you would, what you were thinking that. Tell us, if you would, realize that when you decided to have a conversation with the reporter. What you were thinking that you felt you were allowed them to do exactly that which Judge Wright cautioned you not to. What you were thinking that you
I was
felt
caught
you
off
were
guard in
allowed
the
them
hallway
to
when
do
I was under
exactly
extreme
that
emotional
which
distress
Judge
after being
Wright
here,
cautioned you not to.
hearing different testimonies about my father's murder, and when I spoke to the reporter, I made sure not to talk about any of the testimonies or anything that happened in the courtroom or my testimony.
What did you discuss with the reporter?
I made sure not to just how I felt about the situation and who my dad's character was
What did you
as I
discuss
saw him.
with the reporter? When you say about the
Just how
situation,
I felt
about the case,
and
the trial,
who my dad's character was as I saw him.
what situation were you referring to?
My emotional state and
The trial?
who my dad's character was as I saw
Post
him.
on social media,
I do.
TikTok, the trial,
Yes.
any others? You
No.
post on follow media,
I do.
your testimony here at the trial.
Yes.
Last Tuesday, did you make any posts on?
I did.
Tell us how many
I
were
did. 3.
TikTok. 3. And tell us one at a time. Were all
did.
3 of them on Tuesday afternoon, Tuesday evening?
3. One was on Tuesday.
And when were the other 2?
Yesterday. I did.
3 of them on Tuesday. And tell us as to the first post.
One was on Tuesday.
What was it about? And when were the other 2?
I said that I testified.
3 of them on Okay. And tell us as to the first. Did you have anything to say about testifying?
I said that I talked about it being on live television.
Okay. And what else? Did you have anything
That
to
somebody
say
back
about
home was watching.
testifying?
I said that I talked
I
about it being
assume
on
you
live
have copies on
television.
your phone?
I do.
You have your phone with you here today?
It's not on me.
Where is it?
It's over in the benches.
In the bushes?
In the benches.
In the benches here in the courtroom?
It's inside.
With the court's permission, may she retrieve it so we can see exactly what it was that she posted?
In the benches.
In the benches here in the courtroom?
It's inside.
With the court's permission, may she retrieve it so we can see exactly what it was that she posted?
Not if it's on social media, but we started off talking about just speaking with some reporter, now we're talking about a social media post. If you've seen it, if you violated the rules, let's just get it out. Speaking with some reporter, now we're talking about a social media post. So if you've seen it, it's a fishing expedition. Let's just get it out. If you know a violation, let's talk about it. If not, let's just get moving. We've got jury. It's a fishing expedition.
I understand that, Judge. How do I know? Like she's told us she posted 3 things. How do I know what it's about? I understand that, Judge. And how do I know, like, discussions that were inappropriate? How am I to know what it's about? I've been a little preoccupied, and I don't do social discussions that were inappropriate. How am I to know what it's
Sir,
about?
if you have specific evidence, let's talk about it. If not, you have a team, you've got 1, 2, 3 people in court right behind you. I don't know, maybe they can look it up. If not, but let's focus on what we know about as opposed to digging into speculation. I don't know, maybe they can look it up. If not, but let's focus on what we know about as opposed to digging into speculation. When you had this conversation with the reporter in the hall, were there any other witnesses around? When you had this conversation with the reporter in the hall, were there any other witnesses around?
I'm sorry. Let me re-answer that question. None that testified. I think.
Okay, so you're saying there were people standing around,
Re-answer that
but
question.
none of the witnesses in this case?
No, sir. None that testified. I
Did you talk specifically about the questions that were asked of you or the testimony you've given?
No, sir.
Did you talk specifically about the questions that were asked? Do you have any follow-up questions to my questions? Testimony you've given?
No, sir.
Do you have any follow-up questions to my questions? Did you talk specifically? All right, Ms. Benefield, you can step back. Do you have any follow-up questions to my questions? Did you want to call any other witnesses? Do you have any follow-up questions to my questions? State. All right, Ms. Benefield, you can step back. Do you have any follow-up questions to my questions? Did you want to call any other witnesses? Do you have any follow-up questions to my questions? State. All right, Ms. Benefield, you can step back. Questions to my questions. Did you want to call any other witnesses? Do you have any follow-up questions to my questions? State. All right, Ms. Benefield's out of the courtroom. Go ahead, sir. You have any argument? You want to seek any relief? You want to argue in support of any relief? State. All right, Ms. Benefield's out of the courtroom. Go ahead, sir.
Admonition.
You have any argument? You want to seek any relief? You want to argue in support of any relief?
And as a result, again, admonition, no personal interest, routinely in some releases, and as a result, the court's admonition, given a strike for no personal interest, in some releases.
Judge, I think you asked a lot of questions. Questions you asked about admonitions that you gave her as a witness, and she did not raise it. Judge, I think you asked a lot of
Final thoughts?
admonitions.
I am certainly distressed that, let me say first, the media policy for the 12th Circuit prohibits the media from conducting interviews inside of the courthouse. It is my understanding that our media and public relations interviews inside of person met this morning and was going to meet this morning with the media to go over the administrative order again, because certainly I think the media is and should be aware of that administrative order and comply with it. Because certainly I think the media is specific incident that we're talking about after hours yesterday. The facts that are in front of me are not that Ms. Benefield spoke about her testimony or the questions asked. The facts that are in front of me, but I also have not heard from the reporter, and I have not seen any tape or footage or questions asked. At this point, I'm going to reserve on the request, but I'll make a decision. If and when she's called in, I'll make a decision at that point. You just have to remind me if we get there. I'm going to reserve on the request, but I'll make a decision. If and when she's called in, I'll make a decision at that point. You just have to remind me if we get there.
Deputy, you just start. I don't care about the order. Just start bringing the jurors one at a time at that point. Deputy, you just start. I don't care about the order. Just start bringing the jurors one at a time.
Yes. Yes, but I'm going to give her an admonition.
Deputy, you just start.
If you tell him to just hold up for a second, but I'm going to she can come back in. At this point, I'm reserving on whether she can be recalled or not. But I think an admonition at this point is appropriate. Him to just hold up for a second. Yes, but she can come back in. At this point, I'm reserving on whether she can be recalled or not. But I think an admonition at this point is appropriate. Yes, she can be under Marcy's. At this point, I'm reserving on whether she can be recalled or not. But I think an admonition at this point is appropriate. Yes, she can be under Marcy's. At this point, I'm reserving on whether she can be recalled or not. But I think an admonition. All right, Ms. Benefield, you can stop right there. Ma'am, the court has ruled at this point that I'm reserving ruling on whether you're going to be allowed to be recalled as a witness or not in this case. I don't know if that's going to happen or not. I'll make that ruling down the road. But I want to admonish you about the instructions that I've given. I don't know if that's going to happen or not. I'll make that ruling down the road. But the importance of those, they matter and they need to be followed. Do you understand? All right, ma'am, you can retake your seat. Down the road. But the importance of those, they matter and they need to be followed. Do you understand? No. All right, ma'am, you can retake your seat. Down the road. But the importance of those, they matter and they need to be followed. Do you understand? No. All right, ma'am, you can retake your seat. Down the road. But the importance of those, they matter and they need to be followed. Do you understand? No. All right, ma'am, you can retake your seat. But the importance of those, they matter.
Morning, sir. You can just grab this front chair, it's just fine. And can you remind me, please, what juror number you were? You can just grab this front chair, it's just fine. Juror 33, the reason I'm going to bring the jurors out individually is that this morning, the court was provided a letter from a law firm representing a reporter this morning who indicated that during the lunch break yesterday, from a law firm, the news reporter representing a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing her out to find out, did that happen to you? Have you received any information outside of these four walls? So I didn't bring her out to find out, did that happen to you? Have you received any information?
State, do you have any questions? Defense? No, sir.
Thank you, sir.
State, do you have any questions? Defense? No, sir.
Thank you, sir. Good morning, ma'am. Just grab that first chair. And could you please remind me which juror number you were? Good morning, ma'am. Just grab that first chair. And could you please remind me, the reason I bring about jurors individually is that this morning I was provided a letter from a law firm in West Palm Beach that claims to represent a news reporter. I was provided a letter from and the news reporter anonymously has stated that during the lunch break yesterday, the reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred in earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to earshot. Have you seen any news coverage? Have you heard people discussing the case? Received anything outside of this one? Have you seen any news coverage?
State, do you have any questions? Defense?
Thank you. Received anything outside of this one? Have you seen any news coverage?
State, do you have any questions? Defense?
Thank you. Good morning. Have a seat right there. And could you do me a favor and remind me of your juror number?
Defense?
Thank you. Good morning. Ma'am, the reason I'm calling out the jurors individually is because this morning I received an email, a letter from a law firm in West Palm Beach who claims to represent a reporter. This morning I received an email, and the reporter has anonymously stated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm asking everybody, are you familiar with that? Has that happened to you? Did you see any information outside of this juror in the case? So I'm asking everybody,
State, any questions? Defense?
Thank you. Has that happened to you? Did you see any information outside of this juror in the case? So I'm asking everybody,
State, any questions? Defense?
Thank you. Has that happened to you? Oh, good morning. Have a seat right there. It's fine. Could you remind me of your juror number?
Defense?
Thank you. What do you do? Thank you. Oh, good morning. All right, ma'am. The reason I'm calling out the jurors individually is because this morning I was given a letter from a law firm in West Palm Beach who claims to represent an anonymous reporter. And the letter says, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing inside this testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I bring everybody out, the conversation occurred. Are you familiar with this? Have you heard of this? Have you been approached by anybody? Have you done have watched anything on TV? Anything about this? Are you familiar with this? Have you heard of this? Have you been approached by anybody? Have you done
I'm not going to the restaurant area, and simply because we saw some people out and about, I'm not going to the restaurant area, best to just still clear up all that. And no, I have not simply because we saw some people out and about, I'm not going to the restaurant
Thank you.
area, best
State.
to just still clear up
Defense?
all that. And no, I have not simply because we saw some people out and about, I'm not going to the restaurant
Thank you. State. Defense? Good morning. Just have a seat right there, that'll be just fine. And ma'am, could you remind me of your juror number for Monday? Thank you. Good morning. Ma'am, the reason I'm calling the jurors out individually is because this morning I was provided a letter from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And here's what the letter says. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to say, are you familiar with this? Did you see any of this? Have you to be anything to look at or hear? So I'm bringing everybody out anything outside of this court. Did you see any of this? Have you to be anything to look at or hear? So I'm bringing everybody out anything outside of this court. Did you see any of this? Have you to be anything to look at or hear? So I'm bringing everybody out anything outside of this court. Have a seat. And could you please remind me of your juror number?
Just from the it's on my day, number 21.
Thank you so much. All right, ma'am, the reason I'm talking to each of the jurors individually is because I received a letter this morning from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And what the letter says is during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within the earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to say, are you familiar with that? Do you know anything about it? Or have you done anything outside of these four walls during this trial? Do you know anything about it?
I'm not aware of the situation. I do know one of the jurors had, I believe mentioned he was going to lunch. And he mentioned that he did get it, he got it from Ted. I believe that's all he mentioned, he said he felt uncomfortable. And
Thank you, ma'am.
he mentioned that he did get it,
Hold on.
No,
you're fine. They just like in trial, they get a chance to ask their questions too. Thank you, ma'am. No question. All right, thank you, ma'am. You're fine. They just like in trial, they get a chance to ask their questions too. Thank you, ma'am. Good morning, ma'am. Could you please remind me of your juror number?
my original one or two?
Original.
29.
And good morning, ma'am. Ma'am, the reason I bring everybody in individually from the jury is because this morning I received a letter from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And here's what the letter says. Because this morning I received a letter during lunch yesterday. The news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I bring everybody out is the conversation. Know anything about this and heard anything about this, and also have you to be a juror. Viewed or seen anything outside of this court. Know anything about this and heard anything about this, and also have you to be viewed or seen anything outside. Thank you. Thank you. Hello, sir. Can you please remind me of your juror number for Monday? Thank you, sir. Hello, sir. The reason I'm bringing all these jurors out individually is because I received a letter this morning from a law firm in West Palm Beach, and they claim to represent an anonymous reporter. And here's what the letter essentially says. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So they're calling everybody out individually to say, do you know anything about this? Are you aware of this situation? And also, have you been following the court's admonitions? Have you been influenced? Have you seen anything outside of these four walls? Have you been following the court's admonitions? Have you been influenced? Have you seen anything outside of these four walls?
My view wasn't looking at it on the news, and I left immediately because I felt uncomfortable. I was back to the restaurant on the restaurant that I used to watch, and I left immediately from
All right, sir. So when you said you weren't paying attention, was that to the television?
That's correct. I was not in any view of television at all, so I asked
So when you said you weren't paying attention, was that to the television?
That's correct.
And did you overhear two individuals in that restaurant discussing a witness's testimony? And did you overhear two individuals in that restaurant discussing a witness's testimony? Hello, man. Can you please remind me of your juror number from Monday?
What was the number?
Can you please remind me of your juror? Here's why I'm calling everybody out individually. This morning I received a letter from a law firm in West Palm Beach, and I want to talk to everybody individually. And they claim to represent an anonymous reporter. And the letter says, and I want to essentially, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I'm calling everybody out individually is just to say, do you know anything about this? Have you heard anything about this? And have you seen any news or anything outside of these four walls? Just to say, do you know anything about this? Have you heard anything about this? And no, have you seen any news or anything outside of these four walls? Just to say, do you know anything about this? And no, have you seen any news or anything outside of these four walls? Just to say, do you know anything about this? No. All right, the jury's out. The state, do you want to be heard on this issue? Defense?
No.
All right, the letter that I received from the law firm, all right, the jury's out. The state, do you want to be heard on this issue? Defense?
No.
All right, the letter that I received from the law firm, all right, the jury's out. The state, do you want to be heard on this issue? Defense?
No.
All right, the letter that I received from the law firm, all right, the jury's out.
Confirm these. Okay. That he requested it.
Okay. The deputy has informed me that somebody in the audience was at the same restaurant
That he requested it.
and,
Okay.
again, this is hearsay within hearsay, that somebody in the audience was at the same restaurant would confirm that the Again, this juror asked for the television to be turned off. Would confirm that. Does anybody want me to find out who that is and have them brought forward? Asked for the television to be turned off. Does anybody want me to find out who that is and have them brought forward? State television to. So, is there anything else we need to take up before we get started with? Does anybody want me to find out who that is? Today's case. State television to. So, is there anything else we need to take up before we get started with? Does anybody want me to find out who that is? Today's case. State television to. So, is there anything else we need to take up before we get started with? Does anybody want me to find out who that is? Today's case. Okay. All right, let's go ahead and bring the jury in. Okay. All right, let's go ahead and bring the jury in. Okay. All right, let's go ahead and bring the jury in. Are you all can have a seat? Welcome back, everybody, as a group again. Just need to confirm that. Are you all can have a seat? We kind of talked about this individually just a moment ago, but that no one has talked amongst yourselves about the case or began your deliberations. No one's talked to anybody outside of the jury about this case, and no one's done any research on the people and places, things, or legal projects. We've heard anything about anybody outside of the jury about this case. When we left off yesterday, the state was still presenting its case. State, call your next witness.
State Code Sergeant Brian Hewitt.
When we left off yesterday, the state was still presenting its case. State, call your next witness.
State Code Sergeant Brian Hewitt.
When we left off yesterday, the state was still presenting its case. State, call your next witness.
State Code Sergeant Brian Hewitt.
When we left off yesterday, the state was still presenting its case. State, call your next witness. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair, get about 12 to 15 inches from the microphone. It does adjust up, down, left, right. My name is Judge White. I'm presiding over the case. You can allow for the voice right into it. Make yourself comfortable in that chair, get about 12 to 15 inches from the microphone. It does adjust up, down, left, right.
Good morning.
Please state your name and spell your first and last name.
Brian Keelis, Brianquiles.
Where do you work?
Manatee County Sheriff's Office.
Please state your name. How long have you worked? Spell your first and last
About
name.
19 and a half years. Brian Keelis.
What is your current position with them?
I'm the supervisor
Where
of
do
the
you
technical
work?
service in Manatee County Sheriff's Office.
And you're, I don't know if I said this, you're a
About 19 and a
sergeant?
half years. Brian
Okay.
Keelis.
And what is the technical services unit?
I'm the supervisor.
Where
It's
do
a
you
unit
work?
that gets involved in the technical
And
aspects
you're,
of criminal
I don't know if I
investigations.
said this, you're a
One of the
sergeant?
responsibilities
Okay.
is
And what is the technical services
downloading data
unit?
from cell phones and analyzing that gets involved in the technical
And
aspects of
prior to
criminal
your current
investigations.
position, what
One of the
positions did you have
responsibilities
at the
is
sheriff's office?
several. I started on the road and over to cops unit.
And prior to your current position, what
Eventually moved
positions
over
did
to
you have at the sheriff's
Special
office?
Investigations Division as an undercover detective for a couple of years. After that, there was a position involved in, again, technical special aspects of investigations. It just wasn't called the Technical Services Unit at the time. After that, there was in that position until I did that position for a number of years until I was promoted, and eventually in that Technical Services Unit started, and that's that's when I started supervising a number of years
And
until.
what training and education do you have to do your current position?
I've had probably around 800 hours of various technical training, some related to cell phones, some related to technical surveillance, but roughly 800 hours of total technical training.
And I want to talk about specifically cell phones and how you deal with those. So how much training would you say you've had in cell phones and analyzing cell phones?
It's probably a third of that 800, so around 250, 260, something like that.
Okay. When you do what I call a forensic examination of a phone, what do you do? Just briefly.
It's really a case-by-case basis. There's each phone is somewhat of a research project. There's so many variables, but ultimately that phone will get plugged into a forensic workstation. The software was used to be able to download or extract that data from that cell phone, and that same forensic workstation will use software to be able to decode or parse that data to be able to review it.
When you download, I call it dump, a cell phone, when you dump the information from a cell phone, is it voluminous?
Yeah, it can be. Yes, it's quite a bit.
And is it easy to interpret without a cell phone?
No, you definitely need a certain expertise to be able to look at it. You need software to make it a little bit more of a convenience to be able to look at it, but definitely need some assistance to get a certain
And
expertise
do you
to
have
be able to look at
programs,
it.
software that helps you with that?
Yes.
What are the names of the ones you use?
To be able to look at it. Our main state program is Cellbrite, and helps us extract the data. If it needs to bypass encryption and bypass locks, it'll help us do that as well. There's other programs that we use, Grayshift, extract all to be able to unlock the data and extract it. We have toolkits that I like to refer to of data or of software to be able to unlock the data and extract it.
And give me a general idea of how many phones you've done this.
Me personally, hundreds. I want to say the unit as a whole has steadily done 200 to 300, leading up to about 2002, and that has increased probably closer to about 500 devices for this year alone.
Okay, so the unit 500 devices for this year.
Yeah, increased probably closer to about 500 devices.
And when you use software like Cellbrite or Grayhawk, so the unit 500 Shift, does it allow you to put whatever data you want, for instance, pick out what you want and put it in an easily readable form?
You can filter the reports that the software displays, and if you only want it to include messages, you can create a report with just those messages. Sure.
So, for instance, on just your average cell phone, if you did a cell phone dump, you would get messages like text messages. So, for instance, on just your email, if you did a internet searches dump, you would get all different things that would be on like text messages.
If those data transactions exist on the phone, you will typically get those.
Internet searches. So this software allows you to pare that down.
If those data transactions exist on the phone, you will typically get those.
In the instant case where you ask software allows to do extractions on two phones.
Yes. Data transactions exist on the phone, you will typically
And I'm going to show you what's been previously entered into evidence as states exhibit on two phones.
Yes.
And I'm going to show you what's been previously entered into evidence as states exhibit. Can you tell me what those are?
These are the two cell phones that I had done examinations on. One of them belonging to Doug Benefield, the other one belonging to Ashley Benefield. These are the two cell phones that I had
the
done
evidence tag that's on there, do you recognize that?
Yes.
And does it have your information on it?
Yes, it does.
Okay.
These are the two cell phones that
So did you go through the process that you just explained with both? Does it have your information?
yes, it does. These are the two cell phones. There were differences in the process, but ultimately, we were able to get a path to data and produce a report for that data. There were differences
And which
in the
one
process,
did you,
but
were you able to extract first?
we were able to get a phone data and extract first, produce a report for that data.
And then were you able to extract data from Ashley? Were you able to extract
We
first?
were able to eventually. It did take quite some time.
Okay, why did it take quite some time? And then were you able to
That
extract
phone,
data from Ashley?
it was a passcode. We had a PIN code. I want to say it was a 6-digit PIN code.
Okay, why did
And
it
the
take quite
software,
some time?
it took a long time to actually bypass that encryption or that PIN.
Okay, so if you don't have the passcode or a way to get into the phone,
It took a long time to actually bypass
your system can do that?
encryption or that PIN. Yes.
Okay, so if you don't
It varies
have the
in length of how long
passcode, a
it
way to get into the phone,
could take to bypass, but yes, the
your
system
system
allows
can
for
do
that.
that? Okay. And you called one of those Doug's phone and one of those Ashley's phones. When you do extractions of the data, okay, do you get information about identifying who owns the phone? When you do, and can you just explain what that is?
A lot of the times, especially with iPhones, you'll have an Apple ID that could be associated with the person that owns the phone. And the contact information, it'll have the owner's information, so it's pretty easily identified who that phone belongs to, especially with iPhones.
Okay, and the one phone, I'm not sure if it's 11 or 12, that you said was Doug's phone.
So it's pretty easily identified
12.
who
Did that have identifying information?
Yes.
Okay, that identified as Doug's. Correct. And then for Ashley's phone, same question.
Yes.
12. Did that have identifying information?
Yes.
Did you prepare a spreadsheet for this case?
I did.
And what is on the spreadsheet?
Yes.
12.
It was communication between Ashley and Doug extracted from Ashley's phone from September 20th of 2020 until September 27th of 2020. Ashley and Doug extracted from.
And when you say communication, what do you mean?
In that particular report, it was mainly text messaging back and forth. There were a few phone calls and I want to say at least one email, but mostly text messages.
And did you said you prepared the spreadsheet from Ashley's phone. Did you also look at the information from Doug's phone to compare to that information was on his phone as well?
Yes.
And was the spreadsheet from Ashley's phone. Did you also look at the information from Doug's phone to compare to that Exhibit 9 on his phone as well?
Yes.
And was the spreadsheet from Ashley's phone. Did you also look
I
at
do.
the information from Doug's phone?
This is the CD containing the Excel spreadsheet that we just talked about.
And was the spreadsheet from Ashley's phone?
I do. This is the CD containing the Excel spreadsheet that we just talked about. Yes, they were. Yes. I do. This is the CD containing Yes.
And is it accurate
based
on the spreadsheet?
Yes, they were. Yes. Yes.
Any objection to States Exhibit 98?
Yes, they were. Yes.
Proceed.
Yes.
Any objection to States
So
Exhibit
I'm going
98?
to publish the
Yes.
spreadsheet now. If we can turn down the lights and potentially, it's a little difficult to read, potentially shut the line. I'm going to publish the
Yes.
spreadsheet now. If we can turn down the lights and potentially, it's a little difficult to read, potentially shut the line. I'm going to publish the spreadsheet now. If we can turn down the lights and potentially, it's a little difficult to read, potentially shut the line. So I know this is very small, at least from where I'm sitting. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if I have handed you an exact copy, a hard copy. So I don't know where it's easier for you to read. I know that print is very small. I don't know if Are you going to read from the one in front of you or the one behind you?
I'm going to attempt to read the one in front.
Okay, because I can try and make this a little bigger once we get through from the one in front of you or the one behind you.
I'm going to attempt to read the one in front.
Okay, because I can try and make this a little bigger once we get through from the one in front of you or the one behind you. And I have one as well. I do want to talk a little bit about these attachments that are on the phone or on this spreadsheet. I have one as well. Are you able to tell when you look at one of these attachments that are where that image or picture or video came from? Are you able to tell?
It depends on each attachment. There could be metadata there that the attachment could have been from a screenshot. It could have been from the actual phone taken with the actual phone. So just again, case by case basis.
Okay. So there is a video on
It could have been from the actual phone taken with the actual phone.
that,
So
and I just want to draw your attention to it, that shows some people at a restaurant. Do you know which one I'm talking about?
Screenshot. It could have been from the actual phone taken with the actual phone. So
That, and I just want to draw your attention to it, that shows some people at a restaurant. Do you know which one I'm talking about? Let you know which one it is. That, and I just want to draw your attention to it, that shows some people at a restaurant. Do you know which one I'm talking about? Let you know which one it is. That, and I just want to draw your attention to it, that shows some people at a restaurant. Do you know which one I'm talking about? Let you know which one it is. That, and I just want to draw your attention to it, that shows some people at a restaurant. Let you know which one it is. It's line number 25 on your spreadsheet. It's It's line number
Can you
25
tell from what you're
on your
looking at
spreadsheet.
where that video came from? Or do you recall from your investigation before where that video came from?
Based on what I'm looking at, it's an attachment from a text message
Or do you recall
from
from your
Doug Benefield
investigation before where that
to
video came from?
based on what I'm looking at, it's an
Okay.
attachment
And when
from
you
a
looked
text
at Doug
message
Benefield's phone, could you tell whether this movie was taken
Told you,
on
Jeff.
his phone
based on
or
what I'm looking at,
sent
it's
to
an
his phone?
attachment.
And when you looked
I
at
don't have
Doug
a recollection of
Benefield's
the actual
phone,
metadata of
What's
the
up, Lauren?
video itself
Told you, Jeff.
on either phone. This is just
I gave you a
looking at
shout
it
out,
from the
didn't I?
attachment perspective. I don't have the specific actual video.
What's up, Lauren?
The video itself
Told you, Jeff.
on either phone. This is
I
just
gave you a
looking
shout
at it
out,
from the
didn't I?
attachment perspective. I don't have the specific actual video.
What's up, Lauren?
The video itself
Told you, Jeff.
on either phone. This is
I
just
gave you a
looking at
shout
it
out,
from the
didn't I?
attachment perspective. I don't have the specific
What the freak?
video itself.
okay, if we could approach, Judge.
We trying to figure out what was I want to read. The whole time that shit doing? I want to pick it up
Okay,
to the audio.
so let me hook this back up.
Apology game.
And let's talk about what we're looking at first.
Some bullshit
And then I
that's
can
happening.
try and make this a little bigger so people can see it.
All
All right, so the first column just has the number of the entry, correct?
Correct.
Okay, and the second column is what?
It's just the type of entry it is.
And give me a couple of examples of the
Yeah.
type of entry that it is into the phone.
In this timeline, it's labeled as an instant message. If it was a phone call, you would see phone call. If it was an email, you would see email.
Okay, and what does instant message
read
mean?
that
Is
big
that
stat
a
ready.
text?
It's a text.
Okay. And then the third column is what?
It's the direction of that transaction, and specifically dealing with messages, whether it's incoming or outgoing.
Okay, so that would be incoming or outgoing from Ashley Benefield's phone.
Correct.
All right, and then the next column,
It's whether or not that data transaction has an attachment.
okay, and then the next column,
It's the date.
and the next,
And it says time, but it also has the date and the time in the correct time code and time zone.
okay, you said correct time zone. Can you explain that real quick?
So if you see UTC -4, UTC is what's considered standard time for world clocks.
Oh yeah, you told me.
The time where the prime meridian is in the world, you subtract from that and you come up with a time code or the time zone that you're in. We are currently in -4. We're technically -5, but because daylight savings times, we actually subtract -4.
Okay, so does your software do that automatically?
Yes.
Okay, so when it says, at the first line, it says 8:20.02,
Yeah.
and that says UTC -4, that is the current
good,
Florida
though.
Bradenton time.
Correct.
Okay, and then the next column, and I made it bigger on the screen if it's easier for you to see.
I can see it
Okay.
fine here. The party is the people that are a part of the actual message.
Fuck yeah, dude.
And are these the labels, the names that are entered into Ashley Benefield's phone?
Correct.
Okay. And the next column,
All right.
The description will, in this case, the
He's
first
not
one is
taking that
blank,
drug
but
test.
Ultimately it will have the body of a text message.
Waited for him to get out the phone
Sometimes
with
it'll be empty depending on the nature of it, but that's where the body of the text message would be.
okay, so the next
Yeah, buddy.
column,
Because he thought you was on the phone by yourself. He thought it was just you.
The source is just the software's way of
I'm telling
saying
you,
if
Ray
it
don't like
was
talking about shit when I'm on the phone.
if it
So
was a
I'm trying to
native
hear this
message
bullshit
or
you
if
trying
it
to
was
kick. He said,
taken
give
with
him
a third
you
party
give him a
application.
leeway.
Okay.
You like, let
And
me
the
hear
next
this
one.
shit, dog.
The
hear
attachment
what
is
you
the
gotta say.
actual file itself
I hear the
and the
bullshit
file
and
name.
call the bullshit out.
And then the last
Then they
column.
get mad at
The
me.
source file information has a lot of metadata where that file actually exists and file paths and size. And if you look at the table, all
As
this
soon as we
information
get
comes from
activated,
databases, and it explains
Can I make it to the
where
studio
or
from there?
what table
Alright, no, no.
the database that this message or this
It's literally
data
the
lies.
next
Okay.
exit. Get that
So
on
let me
highway
move it
and
back
take the next
over.
exit. Because he would act like he don't
So
know how to
this
take a
very,
straight road.
after we
So
get
I'm making
through
this
this
shit as
explanation, we'll
easy as
move much
possible.
faster. But the first
The same way you
message
got on the highway.
is what? If you could just
Get on the
explain to
highway.
us what that is.
No, buddy. No, buddy. This is the thing. Because you're trying to
Item
like you're
number
telling
one
him
is
what he
listed
already knows.
as a
But
message.
you act like you
It's an
don't know when
incoming
you know.
message with an attachment, and it appears there's no there's no
listen.
body to it. In other
Now
words,
you
there's
gotta
no
tell
actually
him.
text
Bro,
string.
just get
It's
on
just
the
the actual
highway.
attachment itself.
Same way you
And
got
who
off the
is it
highway.
from and who is it
And you
to?
can go
It's
straight
from
back that
Doug
way to go to
to.
studio.
I'm just going to say the name
Because
that's
he's gonna
on
act
the
like he don't
actual.
know
That's
how
fine.
to
It says
take the
Ashley
straight
Christina.
road
Okay.
to the stew.
And is
the
this
back.
the attachment?
That's all I'm saying.
Yes.
Okay. And if you could just read for the record what that
This nigga
says.
just got some.
Says, am I now trying to win the favor and approval of men or of God? Or am I seeking to please someone? If I were still trying to be popular with men, I would not be a bondservant of Christ.
Okay. And then the next message is what?
This nigga on the phone trying to figure
Number
out
two
if
appears
he's
to be
gotta
an
go.
outgoing message. It's from Ashley Christina to Doug Benefield.
And
Right.
how much later than the first message
Yeah, we want help.
is that?
About 2 hours, it appears.
Okay. And so from Ashley to Doug, and what is it?
This nigga.
The description says loved an image.
Okay. So she loved the image from before.
Correct. That's more of an action than actual writing something out.
Okay.
Yes.
She didn't type loved image.
No.
The phone is saying that she hit some button
Correct.
to love the image. All right. And then the next message is from right about the same time, and that says what?
Same time, that says good morning. There's another little icon after it, but it just didn't come out on here.
Okay. And then if you could just continue to read.
The next message, number
Right,
4?
the next
Okay.
message. If you can just say what time,
Okay.
to and from, and then what the message is.
So the next message, sent around the same time, 10:36 a.m. It's from Doug to Ashley Christina. It says good morning with a few emojis. Then the next message after that, appears to be an attachment, and that's at 11:43 from Doug to Ashley Christina.
And what is the message right after that? Oh, I just went too far. Right after the attachment, I'm sorry.
Right after the attachment,
Yes.
it would be number 6. It's a message at 9:20, 11:43 from Doug to Ashley, and it says run baby run with a few emojis.
Okay. And so now I'll just play the attachment.
Run, baby. Run, baby.
Okay. So Doug says run baby run to Ashley, and then what does she do?
That would be number 7. It's a instant message right after. It's at 12:16, and it just says laughed at a movie.
Okay. And if you can just keep reading.
Number 8 would be an outgoing message. It's from Ashley to Doug. It's on the same date at 12:16 p.m. It's just a few emojis. They appear to be laughing emojis.
And you don't have to mention the times right now until it switches a large
Okay.
time.
Apologies,
So go ahead.
gang.
The
that
next
might
would
be
be
loud.
an incoming message from Doug
For some reason.
to Ashley,
My fucking
asking ready to rock and
audio
roll.
is crazy today.
The next is from Ashley to Doug. Give me a few LOL. Trying to round up the cats. It's like trying to teach a ballet to squirrels. The next is an incoming message from Doug to Ashley. Says ha with exclamation points. The next is,
And we've established that it's all either from Doug to Ashley or Ashley to Doug.
Correct.
So if you can just say who's speaking
Shout out
and
to
then the
Patricia
message
Lopez.
from this point.
number 12 from Doug. He says, that's funny. After that, it's from Doug. Says he's liked, give me a few. It's basically liking a previous text message and it just repeats.
Okay.
The next is an outgoing from Ashley. Says, OMG, I'm exhausted, LOL. The next is also from Ashley. You can come over now.
Now, I didn't ask you about the color coding on this, but what do the colors mean?
It was just to make it easier to read which one was outgoing, and on all the outgoings, which is Ashley's phone, are Ashley's phone, and the incoming is the other color.
And so the outgoings are what color?
The outgoings are the blue gray.
Okay.
Yeah.
Or
Did she really kill that
I'm sorry,
man
blue
for
gray.
custody?
The outgoing is the orange.
the orange. Okay. So if Ashley's speaking, it's orange. If Doug's speaking, it's gray.
Correct.
Okay. So I believe we ended it, OMG, I'm exhausted, LOL. Go ahead.
I believe I had stated the outgoing message. You can come over now. Number 16 from Doug. Ha, need to video the rodeo. Okay, headed that way. From Ashley, she responds, she liked what he had said earlier and just repeats. Incoming from Doug, I'm walking around to back.
So did she
The
invite him
response-
over and then clapping?
I could let you in the front, or which, and then adds to that whichever. He responds, okay, front good. She responds with a thumbs up. He responds, me and XS boxes arrived. She responds, LOL. He responds with a message that includes an attachment without a body. Then there's a call log, which is number 26. It's an outgoing call log to Doug for, I believe, 11 seconds.
Okay. And then let me scroll down on here. After the phone call, what happens? Oh, let me back up just a second. What time was that phone call?
Same date, 9/27/24 in the evening.
And then at 8:58 in the evening, that next entry, what is it?
It is a message from Doug. It says, good night, sweetie, theta waves, with a couple emojis. I'll be done by 1 tomorrow and plan on joining the party. And then there's an outgoing, and then again, another action of just loving that previous text message. And then there was a response at 9:23 that says, good night, with a couple emojis. Ha, you sure you want to come hang out with the slum, ? And
Yeah.
9:23, he responds,
left
yep,
earlier.
be smashing
Let the
at
stream
the
going.
slummin'.
So we can catch this case. The audio is crazy. What they censor cameras. Fuck all
there
my
was,
shit.
again, an action of laughed at the previous message.
Okay, so that was at 9:24 p.m. and it looks like the next entry is at 7:36 a.m.
Correct.
My
And
boy
what
out
is
here
that?
just
That
Rollo's
is, believes to be an attachment without a body. It's a long string of characters, JPEG image.
And that came from Doug or to Doug?
That was from Doug.
And I'm going to display the attachment. You don't have to read all of this, but what is this?
Just another Bible verse.
So after the
Shouts
Bible
out to
verse,
Flat Cheese 232.
what is the next thing that
Appreciate the follow,
happens?
man.
She appears that she loves the image and then responds with good morning. He responds back with good morning with several emojis. And hours later, responds with or says headed that way in about 30 minutes.
So that's approximately 3 hours later, he says headed that way in about 30 minutes.
Correct.
Okay, go ahead.
There's a response from Ashley that says, oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now. Not in a rush to get started today, LOL. We'll have to round up the cats when we get home anyway.
She doing a lot of moving while this man reading them text messages got her uncomfortable.
There's a response from Doug, oh nice, a little breezy, which helps. Getting early start so can finish up early to come over and be with y'all and play W Emerson, typically shorthand for with Emerson, free y'all up some, just ping when good to head over.
Yeah, 'cause they got spots out
And
there.
Ashley responds with a like of that previous message. And then responds with will do, and also adds in a new text message, want to grab a can opener at Publix on your way over, question mark, LOL. I of course packed the one we had. He responds, ha, too funny. Yep, yep, we'll get one. She responds, thank you, trying to get the cats, LOL. And after that, there's an incoming message, appears to be an attachment as well. And that was it.
Go ahead. Some of these attachments don't open on this computer. Can you explain kind of why that is?
I think that one of the previous videos that you had, sometimes it's a codec issue. The files are actually not necessarily embedded in the actual spreadsheet itself, but I can take this same file and bring it over to another computer and it might open. It just depends. It depends on the computer how it's set up to open that particular file.
Okay. So after the attachment, I'm trying to slide this back over. Let's see. Let me try to open this. Okay, so this is one that will not open. So I slid it back over. If you could tell us again, starting at 46, I believe it is.
Well, after that attachment, it's 45.
Or 45, sorry.
And it's an incoming, it says from Doug, in the crazy loop at Gay, G-A-Y-E. And it's probably a misspelling because he corrected himself and put gate in the next message. There is a call log that has 0 seconds to it at 3:17, and then an incoming message walking around back, and then.
So the walking around back is approximately what time?
3 o'clock in the afternoon, or 3:21.
The next message is approximately what time?
9 o'clock at night.
And that message is?
Good night. And she responds at 9:22 with good night and looks like a sleeping emoji.
And the next communication?
The next would be an incoming message from Doug to Ashley, appears to be an attachment, some type of JPEG image.
And you don't have to read this, but what is it?
It's another Bible verse. Believe we're on, after that attachment, we're on 52.
Yes.
It is an incoming message from Doug. Says good morning with some emojis. Hope you slept okay. She responded at 9:28. Loved the image, or loved an image, and also an additional good morning. Doug then emphasized the good morning, just another action that he took on a previous message. And the next communication was at 11 o'clock a.m. with a wave emoji, looks like. Then at 11:22, he responds again with how's morning. She responds with also a wave emoji at 11:26, then says, good, the scramble to get all the loose ends tied up, LOL. He responds, no kidding, I'm done. Around 1, we'll head that way. Been going since like 3 a.m., LOL. She responds, OMG, 3, why is that? He responds, just to get work done so can pack. Love mornings all quiet. She responds, ha, okay then. He responds, Spark is best friend, LOL. She laughed, another action for that message. And another response from Doug, finished up here, yay, headed that way.
And what time was that?
That was at 1 o'clock in the afternoon, 1:17.
Okay. And then after that?
At 1:19, she says, oh, take your time, no rush not in a rush today. And at 1:20, a response, LOL, with an emoji, think we all are getting pooped from the efforts. She responds with liked a previous message and it just repeats. There is also a laughed at LOL, again laughing at a previous message. Then another message at 1:36 says, can you think of anything we need at Lowe's or anywhere? Then there's an actual call log at 1:42 that lasts about 49 seconds. And that was from Doug to Ashley. And then at 3:30, there's a message from Doug, headed that way in a few minutes. I'd nothing need. And a message from Ashley, alrighty, we are just out for a walk, still can't think of anything needed at the moment. There's an action liked already, and the message repeats from a previous message. Doing front gate, I'm assuming circle, but CIRCL, and a call log from Doug to Ashley with 0 seconds. Incoming from Doug, I'm here, and it looks like another call log for about 20 seconds.
And that's about, I'm sorry to interrupt, that's about what time?
That was at 3:56 in the afternoon.
Okay. And the next message is at about what time?
9:26 p.m. It's a message from Ashley Christina to Doug. It says good night with an emoji. And then after that, Doug responds, good night, precious girls. And after that, Ashley, again, an action of loving that previous response. And the next several messages appear to be related to attachments.
Okay. So the next attachment I'll put up. Who were these attachments sent from?
These were from Doug to Ashley Christina.
And then in the middle of this, so it would be, I'm not getting the lines correct, but I think it's line 87 maybe, at 9:29:35.
9:29:35 is line 86.
Okay,
And that's another action of loving an image.
okay. And there's one more attachment, I believe. Possibly one more after that. 2. So all of these attachments were sent from Doug's phone to Ashley's phone?
Correct.
Okay. And then there's a series of responses from Ashley. Can you tell me what those are?
It's the previous action that we've referenced where she physically takes an, it's not word that she's typing, it's just physically within the operating system of iOS, it allows you to take an action on an image. In this case, she loved 1, 2, 3, 4, 5, 6.
Okay.
6 images.
Okay. Let me get it back centered again. So after she loved the images, there's an entry where she types a message. What is
Yes.
that?
That's at 9:31 at night. She responds, "Aw, these are sweet, thank you." And he responds with an action that he loved the previous message, and then responds with y'all rock my world with a heart emoji. And she responds again with an action of loving that previous message, and with, it's a very small emoji, hard to tell what it is, after the action.
And then what's the next entry?
The next is an instant, is a message with an attachment, and that's from Doug to Ashley at 6:47 in the morning.
I'm going to pull up the attachment. And again, what is that?
Appears to be another Bible verse.
And if you can continue.
So after, there's a message from Doug, says good morning with emojis, and then also an additional message at 9:28 that says got an email from Stephanie after she talked to Faith. Since order to mediate will meet for 1 hour tomorrow. To stop court next week, you dismissed injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs. Order for report. As soon as she signs order, we file dismissal, and we're done. Looks like praying hands emoji and a heart. And then there's an additional message after that. And we have joint session with Dr. Q Friday to wrap up our adventure in Florida, FL, and leave with understanding of double knots and red-blue inversion. After that, there's an action by Ashley Christina that said loved an image, and it continues with a good morning, and there's an emphasis by Doug of good morning. Ashley Christina responds, oh, okay, I'll reach out to Faith to follow up on all the above with a thumbs up. Doug takes an action and liking that previous image, and then says, and we're done. Again, praying hands emoji, and also responds, and all in first 10 days of Jewish New Year, LOL. It continues with an action of laughed at the previous message. And then at 9:57, Doug responds, you gotta laugh, September 18th was first day of Jewish New Year, 3 years to date of your Odyssey starting day of ballet launch, Rosh Hashanah, the first of the Jewish days of awe. We can call our Odyssey the days of all, LOL. At 10:13, there's an incoming message, says from Doug,
Appreciate everybody on
outside.
YouTube,
It's like a
Twitch,
sun emoji.
and Rumble.
Ashley responds
Sorry about the
with
audio
an
earlier.
action for those previous messages,
Won't
which
have
just
it in
repeats,
law.
and then writes, oh yay, we should do Selby today. He responds, oh yes, with multiple M's and yum. She responds with a few emojis. He emphasized the emojis, and then adds, Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do, just one pager, and also responds, what time thinking Selby? Ashley Christina responds with the action of liking it, and then says, maybe 1:30-ish, I'll text you when we're headed that way with a thumbs up. He responds, or Doug responds, okay, I can come pick you up too. Then adds more time with my baby. Then adds mediation tomorrow by Zoom 10:30 and be quick. Ashley responds with the action of liking that. Then added, sorry, just looking at my phone. You don't need to drive all the back to LWR to get us if you are already downtown. But if you want to, that's fine. Just let me know either way. Doug responds, I'm at apartment. Adds, so pretty, enjoying pool area, finally to work, LOL. The next message is an attachment with no body.
From Doug,
That is from Doug to Ashley Christina.
and I'll pull up the attachment.
Ashley Christine. Is that the lawyer?
I don't know why I just closed that. Let me open it again.
She was flustered, my boy.
And what number were we on?
132, that was the attachment.
Thank you.
For sure. She did some shit she did not like. She getting mad in the face.
Okay. So after the attachment, what's the next
She looking.
communication?
She want to read them messages. She want
It's
to
a
read them
message
messages.
from Doug to Ashley Christina. I'll just head your way at 1:30. Ashley Christina responds, "Ha, nice, okay, just getting our things together now. Maybe head over in like 10 minutes. 10 MIN. Doug responds, okay. And then after that appears to be an email from Doug to Ashley.
Okay.
Why is the cameraman zooming in?
And after that?
You can't
After
even see the
that
messages, though.
is incoming message from Doug. Do you want to get together tonight or in morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out." She responds, "Ha, okay, thumbs up." He responds, "Thumbs up. Prefer tonight, maybe run over Pandera or in AM, question mark." And she responds, "Sure, can do Panera tonight."
Okay, so I want to back up a little bit. We were talking about
Come on,
the entry
cameraman.
that was the email
Get it right.
before that. Does it have the content of the email in this spreadsheet?
Appears there's quite a bit of metadata involved, but the actual content from what I'm looking at is not actually in there.
Okay, does it say any names associated with the metadata?
There's an email address of Stephanie Murphy. It's at murphylawsarasota.com. There's an email address related to Doug Benefield. And there's, I believe those are the two names that I see that are associated with.
Okay. So we left off at sure can do Panera tonight.
Yes. And
So they
adds
said that she did this
8
shit out of
question
anger
mark.
because he
She responds with a
messed with
thumbs
somebody
up.
else?
And that was at 7:27 p.m. And she
Questions.
responds with at 9:55 p.m. with a good night and a sleeping emoji. And he responds also with a good night with another
This
emoji.
cameraman, bro.
He adds sweet dreams and
He's
then
not
also
doing it,
sends an
gang.
attachment. Correction. The sweet dreams was the last one at 9:56 p.m. The attachment I just referenced was actually 7 o'clock in the morning the next day.
Okay, so the next day I'm clicking on that attachment. And what is that?
Looks up here a Bible verse.
And what are the messages after that?
All right, so attachment. After that, there's a good morning with a few emojis. If you want, you can come over here for Zoom. And adds, we can grab bagel and CHI. It's 10 a.m. BT, by the way, BTW is just short. And then there's a phone call at 9 o'clock, 9:07 with no seconds. There's a 151. It says there's an incoming message with no body. And then after that, there's an incoming message with an attachment. It appears to be related to connection to a Zoom meeting, possibly. And then
I'm going to click on that attachment and see if it will come up. It's one of those that will not come up, so go ahead.
the next after that appears to be an ID number and a password typically associated with Zoom meetings, and then a phone call with no seconds. And then 9:38, it continues where Ashley Christina loved an image, then liked the message. It's 10 a.m. by the way, and then added, "Ha, oh man, okay, thanks for the heads up." He responded by liking that, and then added, "Set up here if easier for you." And she responded, "That's okay. I guess I should brush my hair and change out my PJs. LOL, I think I can just do it from my phone." He responds, "LOL, you can." She liked LOL you can, and then added quick and easy LOL.
And what was the time difference between the like of LOL you can and the quick and easy? Approximately.
About 15, 20 minutes.
Okay. And then what was the next entry after the quick and easy?
So it was another action by Doug for that quick and easy, and then added so nice to experience quick and easy, finally LOL. Then adds smeshing good. Then adds PS, you looked great for just rolling at a couch, LOL, and added an emoji. He added, I'm working on brief, head over soon as get to stopping point like 1. She responds with the action of loving the previous message, or one of the previous messages, so nice to experience quick and easy. Laughed at also the PS, looking great comment. And then added, ha, thanks, figured I should put a clean shirt on even if I had PJs on the bottom half, LOL. She adds, and okay, just let me know as you're finishing up. He adds, just to ponder while I finish up, thinking about getting all the cars up here, and I thought was to ship the Cherokee up there by transport, which is $900, and either tow my truck or tow to your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul, more flexibility, like taking things straight to storage. She responds, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and Cats will go in the Jeep and I'll drive with Emerson in my car. She added LOL, the Beverly Hill. He added LOL, the Beverly Hillbillies, coming from dem slums. Forget about cat courier requirements, LOL. She laughed at the Beverly Hillbillies comment, added LOL, then added, I believe, several cat emojis. He laughed at the emojis, then added headed over shortly, brain approaching short circuit. She added, ha, okay, well, give me a bit longer, finishing up mom's closets now so I can get the cats locked up.
Well, that's
He added, he liked the previous message, and then there was a outgoing phone call to Doug for 38 seconds. Outgoing message from Christina says, headed that way. He responds, or he took the action of liking it. Added, we done good, LOL. We have Dr. Q at 10:30. Good night, with an emoji.
Okay. So the liked headed that way was at what time?
That was at 2 o'clock in the afternoon.
And then the good night was at what time?
It's 8:27
Okay.
at night. Saw 2 of them, apologize.
And then after the good night?
After good night, there's an outgoing indeed LOL good night from Ashley,
Right.
and then after that there is an attachment at 5:45 in the morning from Doug.
Okay. And I'll click on the attachment. What is that?
Another Bible verse.
And the next entry?
Appears to be another attachment roughly 15 minutes later.
Okay. And if you could read what this says?
Live a life filled with love. Another Bible verse, Ephesians 5:2. At 9:26, there's a message from Doug that says, good morning. Minute later, there's an action of loving an image. Second, loving a minute image. And he responds with, Dr. Q's at 10:30. Do you want a CHI? Question mark.
I think that's chai.
Chai. At 9:27, there's a response from Christina that says, good morning. There's a repeated response, previous message, Dr. Q is at 10:30, do you want a chai? And then and bagel, he added to it. She responds, ha, that's okay, thank you. If I do that this early in the day, I'll be done for the day, lol, but thank you. He added, he liked that message. And the next appears to be an attachment from Doug related to possibly a YouTube video. And that was at 9:56 a.m.
And it's another one that won't open. And then the next entry.
It's at 10:40:35 a.m. From Doug, are you able to make Dr. Q okay? She responds, yes, lol, be in a minute. He responds, no rush, he's still not out, lol. She responds, I know, lol, waiting for mom to come out so we can swap. There's a message without just a rectangular square there. And then after that, there's 10:42:35. There's an LOL from Doug. There's a phone call. It's
Now the LOL was at 10:42 a.m. and then what's the next entry?
correct. 10:42 a.m. was the LOL, and then the next is at 5:39 p.m., which is a phone call from Doug, and with 0 seconds. Then adds after the phone call, I be here, and then another phone call for 15 seconds at 5:40 p.m. Then,
Your Honor, not to attack Sergeant Keyless because he's been reading for a while, but it's a little tough to follow. I wonder if he could give us the number of the message, so it would be much easier to follow.
That's fair.
And I don't know why, but I think your numbers may be off. You're,
Okay.
off different from this.
they might be. Can you look?
IB here is.
What's up guys, in
we're
this
not
short
using the
tutorial
numbers that
I will
are
show
built
you how
into
to become a
Excel. I
Twitch
wanna
affiliate,
say
which will allow you
Okay.
to
They're
accept
the
paid
numbers
subscriptions
are
to
an
earn some
actual
revenue while
column.
streaming.
So
This should be quite an
technically,
easy
IB
tutorial,
here,
but if you still have any questions then leave a comment and let
That's
me
what you're
know.
looking at.
correct.
The
IB
requi-
here would be 212.
If he gives you that number,
Where-
are you okay with that?
Can you show him?
Like on yours, 214. It's 214. These numbers here match what he's saying. There's numbers on the Excel spreadsheet showing, that's what was confusing me. But the numbers he's saying are the numbers on the sheet.
Okay, so we're on.
We're
right
on
now,
215, correct?
Correct.
Okay.
Okay, so if you, Sergeant, if you could just call the number out.
Sure. Not a problem.
Thank you. Thanks, Judge.
Of course.
So we left off of 215, which is at 9 o'clock. It's a good night with an emoji. 216 is an attachment, a JPEG. And that was at 6:43 a.m.
And that is on the next day, correct?
Correct.
9/26.
Correct.
And I pulled up the attachment. What is that?
That's like a Bible verse.
And then you can continue from there.
All right, so moving forward, 217 is from Doug with a good morning. 218, she loves the image. And 219, she responds also with a good morning. 220, Doug sends ready to start with a thumbs up. 221 is a call log with from Doug with 0 seconds. 222, there's a message from Ashley Christina. Okay, I'll text you in a bit with an emoji. I can't tell what it is. Pretty small. Next record is 223. Just one of those action messages, liked a previous message, and then it repeats. 224, want to come pick me up and we can go get the truck.
And that's from Ashley.
and that's
correct?
from Ashley.
Okay.
And Doug responds, sure, with 225, sure, headed that way. 226, I be here. And that's at 12:41 p.m. And then 227 is all the way at 9 o'clock in the evening, and it's from Doug, and it's a good night, sweet dreams. Then at 228, 9:23, Ashley responds with the action of loving the previous message, and also responds with a good night. 2:30, there's another attachment at 6:42 from Doug to Ashley.
I'll pull up the attachment. What is that?
It's the Bible verse. After the attachment at 2:31, Doug sends good morning. 2:32, she responds, loved an image. And 2:33 with a good morning. 2:34, he responds what looks like a strong fist up emoji. And 2:35, there's also an incoming from Doug with just a little rectangle. 2:36, she responds with LOL. 2:37, he responds, what y'all working on? And that's at 1 o'clock in the afternoon. 2:38, about 15 minutes later, she responds, last cram, LOL, using big boxes and getting the last loose stuff packed up and ready. And also responds on 2:39, how's it going over there? Making progress? He responds at 2:40, number 240, at 1:18 in the afternoon. Loose stuff should be a chapter in our book, LOL. Got everything out and in garage ready to throw on truck except couch, aka bed. Pretty much emptied. Taking Sully to get his shots, then to doggy spa to get groomed and stay until ready to go. 2:41, he adds, I'll come there after drop him off at 3. .242, she responds with the action of laughing at a previous message, and it just repeats. Another action of liking a previous message, then adds, 244 adds, great, could you run by Lowe's before you come over, grab a few large and mediums. 245, he responds, sure, I need a few too, which is at 1 o'clock in the afternoon. At 2:35, number 246, which is at 2:35 in the afternoon, it's just a like by her, sure, I need a few, which just repeated from earlier, and then adds, just to be safe, let's do 10 of each just for the last bits here. 248, from Doug, he likes the previous message and adds, and 249, okay, let me know anything else if think of. 250, she responds, tape. 251, and also adds LOL. 252, he responds, ha, K. 253, just finished vet, headed to spa, LOL. 254, she laughed at that previous message. 255, he says, headed there. 256, she responds, okay. The next line, 257, I'm here out front. She responds, okay, 1 minute.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time is that during the day?
That's about 3:54 in the afternoon.
Okay, and the next message is at about what time?
3:55 in the afternoon.
And the next after that?
After that, it's 5 o'clock in the afternoon.
So there's an hour and several minutes in between these two?
Correct.
Okay, so after okay, 1 minute, what is said?
Then 2:59, about to head back from Doug, and then the message after that appears to be an attachment at 5:11 in the afternoon.
And I'm clicking on the attachment for the record.
Appears to be.
Go ahead, I'm sorry.
It appears to be maybe the U-Haul truck that they're loading up.
Okay. And that was sent from Doug?
That was 5:11. Yeah, that was incoming. Yes, from Doug to Ashley.
Okay, and then the next message?
The next is from Doug, and this is number 261. Everything in except couch and 10 medium boxes and tutu cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 p.m., was that the last communication between these two?
I believe so, yes.
Okay. Thank you. Judge, can we approach just a moment?
Yes.
Before.
Telephone calls. Members of the jury, there's one legal issue that I need to resolve before we finish up with this witness's direct. So I'm going to excuse you in the back. It should take about 10 minutes. It's my best guess. So please don't begin deliberations amongst yourself. You can communicate outside, send and receive texts, emails, telephone calls, but just don't talk about the case. And don't do any research on the people, places, things, or legal topics you've heard anything about. I'll get you back out here as soon as I can. All right, you all can have a seat. Detective, I don't know to what extent we're going to be talking about the testimony you may have, so I'm going to go ahead and excuse you for right now, just to be cautious. Please understand the rules of sequestration. The rule of sequestration has been invoked. You're not to discuss your testimony or the answers you've given or the questions you've been asked with anybody outside this room. You're not supposed to talk with any other witnesses about the testimony they've given or the questions they've been asked. And to my understanding is maybe online, you're not to watch or view anything related to this case until you're released from your subpoena or the jury's returned a verdict in their discharge.
Understood.
All right, so just step outside and get you back in as soon as we can. No, I think it's fine because I think they're still going to need them down. I can see all right. Okay, the detective is out of the room. We can have argument on this video.
Thank you, Judge. And thank you for rehearing the issue. I had a chance to research it. We obviously weren't.
If you've got case law, contrary to what people may think, I want to make the right decision. So if you've got case law, I want to hear it.
Thank you, sir. I actually just sent one to the printer because I didn't know if you'd rather have it. But it's called Lumarque. I don't know. Lumarque. It's 44 Southern 2nd. I'm sorry, Southern 3rd, 171.
Say that again.
Sure. 44 Southern 3rd, 171. There's a yellow flag, but it's for a different reason. This case was.
Sorry. Judge, are you looking it up electronically, or would you like a hard copy?
No,
Okay.
I'll take a copy if you have one.
Oh. Give me 1 second, Judge. Sorry.
Oh, that's all right. Is that the only one you've got? No, you can have it.
One at a time. I can do it, Judge.
We printed this for you, but then realized we needed 2 copies, so here's the paper copy.
Sorry. It's not off the front.
Judge, they revoked my copy in favor of the court.
In favor of the court.
We're not going to do anything until you get a copy.
It should come any second.
course, I can't blame their decision, Your Honor.
Into evidence. The
Right, go ahead.
the part that I'm referring to is on the second page. It's a short case, luckily, where my reading of it is there were text messages and photographs, which I think videos and photographs are treated the same in most case law. That's my understanding and my feeling. But that there were images and text messages that could not be authenticated by an ex-wife on the defendant's phone. And the trial court did not allow them into evidence. The third DCA here said the court erred. The images and text messages were found on the defendant's cellular phone.
Can you slow down just a little bit for the court reporter?
I apologize. The images and text messages were found on the defendant's cellular phone, seized pursuant to a search of the defendant's home through a warrant shortly after the alleged incident. This fact was testified by the state's forensic expert and is sufficient to authenticate the exhibits. Here, those phones have been in evidence since the day before. The contents of them were admitted with a trial exhibit today and not objected to. The only thing is this one video was objected to, this attachment. And the state would argue based on this case that we have established this phone was properly searched, properly downloaded, and the material was found on the defendant's phone, the video found on the defendant's phone, and therefore the state would argue it should be admitted.
All right. Mr. Taylor?
Just 1 second, Your Honor. Okay, I distinguish it on 2 bases, Your Honor. They quote U.S. versus Caldwell 11th Circuit decision, holding that authentication of evidence merely requires a finding that the evidence is what it purports to be. Well, that's the exact issue. Sergeant Keyless cannot do that. He can only say this is a video, it was on the phone. He can't say it's a true and accurate reproduction of what took place on that morning. He doesn't know, for example, who was there that might not have appeared in the video, what the motivation was that brought them there. He wouldn't be able to say whether it was under coercive circumstances. I don't think he qualifies to be able to lay that predicate. And second reason why I don't think this case is applicable is in this case, they held that it was admissible because it constitutes evidence of motive. Judge, this is a second-degree murder case. As the court knows, motive in second-degree murder is not an element. There is no obligation that murder be proven. I don't think they can lay the necessary predicate wrong.
State rebuttal.
Just that I think defense counsel's arguments go to the weight, not the admissibility. I think this case stands for the fact that we've entered, without objection, cell phones that contain this video, and then now without objection, the trial exhibit with the attachments and the CD. The objection was just to one after, which I think is also an issue, but I think we don't have to get there. But I think this case stands for the fact that once we've laid the predicate, that this was a properly searched phone and that the data on it was properly removed and the detective testified that everything was in order, then we've laid the predicate for the contents of the attachments to also be admissible based on this case that I can't say the first name of.
What was the date and time of this particular message?
The message was, I don't know that you can read the small print on that, but there's a copy, but it is, if you're wondering if it was before the Panera conversation or after,
I want to know the day and time that this attachment was sent.
it was sent 9/20 of 2020 at 6:40 p.m.
What number are you referring to?
of 25.
And the Excel spreadsheet, which is the data dump from the defendant's cell phone, shows it's in blue. So it's from,
Defendant's phone. So it's from the defendant's phone to, I'm sorry, from
Correct.
the
It's
victim's
from-
phone to the defendant's phone.
right, it's from Doug Benefield's phone
Yes.
to Ashley Benefield's phone.
Yes.
All right. Any further argument? Because I wanted to ask that question, know specifically when.
No, sir.
Anything else?
No judge.
All right. No objection or no judge?
I thought you said, do I have any further
Anything
argument?
else? And you
Yeah,
said no?
And I don't. No judge. Sorry. Yeah.
Okay. Well, as I said, if there's case law out there that is contrary to a prior ruling, I think it needs to be brought to my attention. And what State versus Lumarque, Lumarque, 44 Southern 3rd, 171, at 172 to 173, Florida 3rd DCA 2010, states pretty unequivocally, the images and text messages found on the defendant's cell phone seized pursuant to a search of the defendant's home through a warrant, which it wasn't here. It's my understanding, the testimony that I heard was that they were provided to law enforcement. Shortly after the alleged incident, this fact, testified by the state's forensic expert, is sufficient to authenticate these exhibits. So the issue is authentication, and that's where I had initially sustained, because obviously there was going to be no witness, this Keyless, sorry.
He says keyless entry. That's how to remember it. It helps me.
Keyless certainly could not authenticate the video. And just to be clear, I'm not sure, I think it's on the record that it's going to be a video of the defendant and her mother that's taken by a third party. I outlined it pretty in depth in my order denying the
How can
stand
you
your
not
ground.
authenticate the video? There's them in the video.
And like I said, certainly the technical services unit couldn't authenticate it, saying that it's the traditional way, that it's a fair and accurate depiction of the events of that day. So then I had mentioned that the bench, perhaps the state could lay the silent witness predicate. However, I don't find that the silent witness predicate was sufficiently laid by the detective Keyless. However, apparently, according to this case, it is authenticated by the fact that it was found on the defendant's cell phone that was seized shortly after the incident. And at this point, it's been sufficiently testified to by the state's witnesses and the forensics expert that he did find this video on there. In fact, in addressing the defense arguments, the 3rd DCA goes on to say, regardless of how these images and text messages might have found their way onto the defendant's cell phone, the state has presented sufficient evidence at this stage, certainly
Oh,
in
they're gonna admit
the admissibility that
You don't admit
these
it.
exhibits constitute evidence of motive. As we've discussed, motive is not an element. But the state has made the argument in the past and makes today that the entry of these items is not for the truth of the matter asserted, but to show the relationship and interactions between the parties in the days leading up to the homicide and the normal texts and banter and communication of a married couple that is in the middle of a divorce. So for those reasons, I will reverse my prior decision, and the video would be admissible under this case.
Thank you.
So we did that specifically so you could finish with your direct,
Yes.
and the ruling is made so then it's available on cross. I know we talked about different options, but I'm glad we did it that way because I think it makes a lot more sense.
So we can recall him and play it, and then we'll attend to the witness.
Correct. So when the jury left, he was on the stand.
Oh, I'm sorry.
Right, so I'm just going to put him back on the stand. The jury won't know any different. All right, so if we can bring,
Can we take a quick restroom break?
all right, 5 minutes?
Just 5
Sure.
minutes.
Okay.
Thank you, Judge.
They're gonna do 5 minutes. What we are gonna do, we're not even gonna pause it. We are going to jump on over
You need for the record, we can start with the Commonwealth.
Christina
Good morning,
Ricci.
Your Honor. Jeremy Husband for the Commonwealth.
Shannon Buckingham for the Commonwealth.
Just not for the comment. Good morning.
Good morning.
Good morning, Your Honor. Joshua Wood from Ms. Ritchie.
Good morning, Your Honor. More Berry from Ms. Ritchie.
10 minutes
Good
or
morning.
so.
Everyone, please be seated.
Jump back to
Good morning
the
to counsel.
Ballerina
and
murder
good
trial.
morning to the defendant. So
me
I have
make
a
sure
few
we got
things
volume.
on my agenda for this
Yes, we
morning
do.
before we bring the jury in. And I'm going to go through those with you, and then I'll give you an opportunity to address anything else that you wish to address with me before we
I'm
bring
trying
the
to figure
jury
out why
in.
this shit won't let me flip nothing. They won't let me do nothing.
First, I note that and did review defendant's motion to reconsider my decision that I released last night with regard to the prior bad acts. I'm denying that motion for the time being, but I will be ever mindful of a point that's raised later in the defense's motion to reconsider, which has to do with the cumulative effect of prior bad acts. It's hard to judge that in the ether, but you get a sense of it as the trial starts to unfold. So I mentioned that to the parties because it's something that I have my mind focused on, and I think that I need to have my mind focused on as the case folds out. And I want the parties to know that in advance as they what and whom they're going to use prior bad act evidence, through whom they intend to get that evidence in. But as a general matter, I spent a good amount of time thinking about the issues that related to that decision. I will encourage you to keep coming back at it if you think that, well, I know the defense thinks that the scale is already tipped with regard to that prior bad act evidence, but I'll keep looking at it, and you should keep raising it with me, and I know you will. With regard to the one or two theories of first-degree murder, where are we at?
Good morning again, Your Honor. The Commonwealth's position at this juncture is we would ask for both theories at this point, although we're not per se wed to the fact that if the instructions are given and we don't elicit our anticipated testimony, obviously we wouldn't ask for it at the end.
So
but
what is so as I looked through last night, the extreme and atrocious charge, it seems to me that, well, on the one hand, the instruction says one blow maybe is sufficient for it to be extreme and atrocious.
Right.
Although that's not ordinarily the case, it's usually multiple blows. But it does. The instruction does say that, so the window is fairly widely open. But I don't know what the expected evidence is with regard to if the evidence came in the in the light most favorable to the Commonwealth, how you met out your burden under that.
So obviously,
So
you've already
educate me.
stated that there are obviously 2 stab wounds that testimony will be elicited by multiple individuals. We also are expecting the medical examiner's testimony and again, this is our expectation. This hasn't been confirmed. We're supposed to have a follow-up conversation with the medical examiner, Your Honor, but our anticipation is that she would testify that at least, if not a little more than 50% of Michael Ricci's blood from the stab wound to his heart had collected in his lungs and around the sac of his heart. And we would anticipate her describing what that would seem like and feel like. Again, a little bit uncertain and unclear right now. And then in addition to that, Your Honor, we do have one of the first responders who we anticipate would testify to the fact that his eyes were open when they first responded, Your Honor. So I would argue, in a light most favorable to the Commonwealth at this juncture, that it may be very worthwhile for the jury to be instructed on both theories based on that argument, Your Honor.
Is there any evidence, or do you expect, again, because I'm at a deficit for the facts of the case, is there any evidence with regard to the time of the alleged stabbing and the time that the defendant asked her daughter to call 911?
We don't know that.
Okay. I saw that in the instructions and was wondering if that's the theory that you were proceeding
No, in all honesty, we do not know that. We don't have that information, nor do we expect that evidence to come out, Your Honor.
Okay.
Based on his body temperature, we don't think it was a terribly long amount of time.
Right.
But
so, defense, what do you say to that?
I think that even in the light most favorable to the Commonwealth cannot articulate a theory of extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of human life. A killing that is so shocking as to amount to murder with extreme atrocity or cruelty, so that you can essentially, based on the circumstances of the case, you can start to say things about the mental state of the defendant. Now, there are several factors that you can consider, including, as you said, the number of blows is one of the factors. To find that the Commonwealth has proved beyond a reasonable doubt that a defendant has caused the death of the deceased with extreme atrocity or cruelty, future jurors must consider, or juries must consider, the following 3 evidentiary factors. The first is whether the defendant was indifferent to or took pleasure in the suffering of the deceased. There's no evidence of that. The second is whether the defendant's method or means of killing the deceased was reasonably likely to substantially increase or prolong the consciousness or suffering of the deceased. Now, the testimony I expect will be that Michael Ricci died from a single stab wound, even though there were 2 stab wounds. There was 1 fatal stab wound. And that there is no evidence as to how quickly he died. The mere reciting of the fact that Michael Ricci's eyes were open says nothing about whether he was conscious, sentient, or what, and that's not even really the question. The question is whether the defendant did something in the process of this act to intentionally prolong or substantially
The
increase.
medical examiner is going to testify that at least 50% of his blood mass had collected around the heart and the lungs based on the autopsy. And I don't know the science behind this or how long that would have taken to accumulate it, and that's at the time of death, at 5:30. Right.
Between 4:30 and 4:45.
Well, right, somewhere between the 911 call and...
I'm sorry to interrupt. There was one additional fact that might also help in, I apologize for interrupting. There was also a 15-centimeter deep. That was the wound depth, Your Honor. I just wanted to add that while you're discussing the medical examiner.
To the first,
yes, that was the wound to his heart, which was 15 centimeters deep.
All right.
So the amount of blood that accumulates as a result of the injury is not the question for the question of extreme atrocity or cruelty. The question is whether there's something about the nature of the act that the defendant did which substantially increased or prolonged the consciousness of suffering of the deceased. that was reasonably likely to do so. So yes, in any case where death occurs, you're going to be able to point to some trauma, which was the proximate cause of death, and you're going to also be able to point to the subsequent effects of that proximate trauma, namely the blood in some cases the bruising and the collecting of blood. But the fact that he bled out 50% of his blood does not suggest anything about how long he was conscious.
What about the 15-centimeter deep cut?
That just means the blade went in at least 15 centimeters. Right, correct. And from that, all we know is that the blade went in. So, for example, if the blade went into his body as a result of a tussle and a fall.
Right, but that's taking it in the light most favorable to you, isn't it?
There is nothing that we can do except speculate about the depth of the wound and the extent to which that suggests something about someone's intention to prolong suffering. There's just no evidence of that, and for the court to give that instruction would be encourage the jury to say, well, if it went in 1 centimeter and then she pulled it out, that would have been a normal thing to do under the circumstances. But 15 centimeters in, as if someone has that type of surgical control in the context of any reasonable human interaction like the one we're talking here.
Well, there's a difference between the required exertion to incur a 1 centimeter blow and the required exertion that's required for a 15-centimeter blow.
Is there going to be testimony that the Commonwealth intends to introduce with regard to the physics of that?
I don't know. I'll wait to see what they come up with. But the ME is going to say it was 15 centimeters deep?
Yes.
I'm going to give the instruction. I'm not saying I'm going to give it at the case that comes in. But preliminary today, I'm going to advise them that there are 2 theories, premeditated murder and the cruel and atrocious.
Thank you.
Did either you think about, or both of you think about the prior bad acts limiting instruction? And what do you have to report on that?
We did reach out to Ms. Croker with regard and had her forward the instruction that you did last trial, Hassler, Your Honor, and I have that here. We've reviewed it. We are content with this longer instruction.
Defense, which do you prefer?
Well, I will say that I don't think that either are adequate, particularly with regard to the June 6, 2019 event, in order to overcome the overwhelming prejudice that will create for Ms. Ricci.
Problem, counsel, is that not only is it prejudicial, it's probative. And that's the balancing act that was required to do, for me to do in connection with that. And I understand we disagree with regard to my decision on that. But now you've got the decision, and which instruction do you want?
Can we see the instruction from Ms. Croker's trial?
Sure. Yeah, it's somewhere on the bench. Let me just see if I can find it. I had it here yesterday, so I know it's here. And if the Commonwealth has it,
I just passed it over to defense counsel.
Thank you. Anyway, because if I'm going to give it, Madam Clerk, can you put that out for me just in case I don't find it in my...
I'm asking in the last sentence of the instruction, in the words, he must also have committed the crimes charged in the indictments, to read, was more likely to have committed the crime.
I'd love to follow along with you, but now that I said I printed it out, and I know I did, it's probably in my chamber somewhere, but just give me a minute for Madam Clerk to print it out. since you have the docket, the paper before you, what's the docket number?
We just have an email, so that doesn't have a
Oh,
document.
anybody have the docket number?
Shout out to everybody that's on
that
Rumble,
Madam Clerk can look it up
Twitch.
quickly.
Appreciate all y'all.
Or we can also do old school. We can actually just copy that. But I'd rather have the order, Judge Buckley's order. I know I had it on the bench here yesterday. I'm just looking for the.
For anybody that's trying to
It's
send
order on
tips or
motion
anything like
preliminary.
that, support the channel. What I don't do today actually is to put the link in the comments. Anything in the comments, stream elements link is the link to so appreciate everybody that's trying to support, anybody that's putting that time in, and everybody that's rocking with us. You know what I'm saying? I appreciate all y'all.
One here? Yeah, in a minute, when I get done with the other issues.
2 more minutes, we'll switch back to the other trial, and I'm gonna have to run. Well, not run. I'm only going downstairs. I gotta warm up my food. I haven't ate this morning.
Oh, it's on the second page or the third page. All right, Attorney Wood, thank you for your patience. The last
The last sentence of the instruction.
starts with specifically.
Correct.
Okay.
That second clause, he must, obviously the pronoun, but in
Sure.
addition to that, was more likely to have committed the crimes charged in the indictment, as opposed to must also.
Any objection to that?
May I just ask for defense counsel to repeat that, please?
Yeah, he wants to say
I gave him my instruction. Okay.
she was more likely to have also committed the crimes charged in the indictment.
Okay, that's fine.
All right. The other issues we need to deal with before or address is juror number 6 raised the issue with regard to, and actually I'm going to ask that the camera be turned off for a second because this relates to the impanelment process and I don't think it should be covered.
At this point, we are going to jump back to this other trial. All this, jump back over here.
All right, Detective, if you can retake the stand, reposition yourself as needed. So did you speak with anyone about your testimony or their testimony or anything at all?
No.
Ready to bring the
Again,
jury
if you
back
wanna
in?
support,
Yes.
appreciate everybody, man.
Mr. Taylor?
Locking in, rocking with us.
Yeah.
I appreciate you.
Bring him in.
That I appreciate it.
All right, y'all can sit down. Welcome back, everybody. Anybody begin deliberations, communicate with anyone outside the jury about the case, or do any research on the case? All right, everybody says no. State, you can resume your questioning.
Okay, I just have one thing before I turn witness over. There was an attachment, a video that was sent by Doug. It's line 25. So sent by Doug to Ashley, correct?
Yeah, hold on.
Oh, you don't have the sheet in front of you.
No.
Sorry.
Thank you. Line 25 is an attachment from Doug to Ashley Christina.
Okay, I'm going to play that attachment at this time.
How do you know what it's doing? I think it's giving you clues that I gotta guess.
Is it like with words? I'd say not safe.
Get real?
Second word.
Real?
Working mother. Not a working mother.
Working mother, not a working mother?
Not a working mother. I live in a
Slum.
people said earlier, like, right,
Oh no, it's running out of time.
I live in a
House.
and
Real house. Wife.
So put together.
Housewives of.
Real
Oh, real house. Oh.
Okay, thank you. I have no further questions.
Cross, and Mr. Taylor, do you want the screen or do you want the lights back up?
I'm going to use the screen.
Yes, sir, we'll leave it as is.
Do you want your...
Good morning, Sergeant Caleb.
Good morning.
I want to make sure that we can establish the contours of your testimony. From the technical services unit, you're capable and authorized to extract this information from the cell phones of both Doug Benefield and Ashley Benefield.
Yes.
You don't know the context about the messages. You just are able to read what's printed.
I can read what's printed from the extraction, yes.
Right. But for example, there were quite a few Bible verses. You wouldn't be able to necessarily tell us that Doug Benefield's a very religious guy. You just can tell us, here's the Bible verses that he posted.
Yes, I can tell you that he sent a Bible verse.
Okay. And you can't tell us the reason that either party may have had for sending a particular text. You can only tell us this is what the text says.
Correct.
You can't tell us whether the text is true or false. You can only tell us what the text says.
Correct.
You can't tell us if the text is genuine or motivated by fear. You can only tell us what it says.
Correct.
I'd like to pass you what we've marked as Defendant's Exhibit 3 and ask you if you can identify it.
I would object to be on the scope.
Okay, I don't know.
Come here, bud.
Not yet. No.
I'm going to pass to you, Sergeant Keyless, what I've marked now as Defendant's Exhibit 3. Those would they not, text messages that you also extracted?
I believe these were the text messages that you may highlighted during a deposition, and
Yeah.
we confirmed that these came from, I believe, Doug's phone.
Correct.
Yes.
And that we requested.
I apologize, Judge. I do think we need to approach it now.
All right, members of the jury, this is going to take a little bit longer. So what I'm going to do at this point is, it's about 11:30. I'm going to let you go to an early lunch. So if you could be back downstairs in the jury assembly room at 12:45. That gives you a little bit extra time. That'll give us time to take care of what we need to take care of. And we'll get you back up here as soon as we can right after your lunch break. Please remember, don't discuss the case amongst yourselves. Don't discuss the case with anybody else, and don't do any research on the people, places, things, or legal topics you've heard anything about. All right, thank you.
All right, gang. We're going to jump back to this Christine Ricci trial.
Individuals that may have been seeing the decedent on a regular basis,
Oh,
weekly,
shit.
daily, I don't know how often.
Never
they
stopped
watch
her.
it.
That statement, I'll kill them all, kind of goes
Okay.
to the concept of discovering the name in relationship
trying to cover 'em both.
with this woman
We're trying to
that
cover
he
'em
had
both.
an affair, the belief that he was
We lock it
living
in.
a double life, and that
I'll finish this
statement
plate.
included the
Probably
threat
jump
towards
away, you
Michael
can.
as well. So I just wanted to clarify, because I do think that statement does indirectly refer to him. And so I think
Again,
the order is a
I
little
appreciate
confusing,
it.
and
Everybody for rocking out
I
with
don't
me.
want to elicit
Twitch,
something from the
YouTube,
witnesses
Rumble, all my
inconsistent with the
streams.
Honor's ruling, but I think his
Appreciate all
testimony
y'all.
is going to be
If you want to support
that
the channel,
statement, "I'll kill them all,"
hit the
is the
Stream
statement
Labs
that
link
the defendants say.
All right,
in the bottom.
Spence?
Hold on, guys.
There's a number of things I think that need to get clarified with regard, even given Your Honor's ruling about prior bad acts, and I think I also need to make a record about some of them. I understand the court's position with regard to all of it, and in particular the January 6, 2019 event, and I won't belabor that issue. I do think there remain additional issues with the group of prior bad acts that are being offered, which are observations made by third parties of Michael's face during a period of time.
I want you to address this argument.
The Higgins argument?
Yes, and then I'll let you put whatever you want on the record when you stand up when I ask you, is there anything else that you want? But I want you to keep your eye on the ball, Attorney Wood.
Okay, I thought that's what you were doing. I
No,
apologize.
all I'm asking you is with respect to this issue.
Okay.
And by the way, you all know, and I've said this not a million times, that would be an overstatement. I've said this a number of times. You know the facts of the case. I do not. I rule on what is before me and what was before me in the Commonwealth's motion. And here's where I draw out the line. It is not relevant to this jury's decision-making whether she threatened Janine Bouchard, whether she threatened anybody else. It's only relevant to this decision-making, this jury's decision-making, in my opinion, as to whether she threatened to injure or kill the decedent. And if they can't be divided out, then it's not coming in.
Oh, well, that's my position too. It shouldn't come in.
I figured it was, so I cut to the chase. All right? Now, there are going to be things, I don't know what's coming out in the testimony, and in your motions cannot, you can anticipate to some degree, but now that you've done the preps, or as you do the preps, you're going to be in a far better position. That's sort of the dividing line in my mind as to what is admissible and what is not. And if it's not divisible, particularly given the cumulative effect of some of this evidence, it's not going to come in. All right? When in doubt, come to the side of the bench. I'm going to go back to the Commonwealth. Is there anything else that you need clarification for in this? If I can clarify it.
I think we are ready to go, Your Honor. Thank you.
All right. Attorney Ward, go right ahead. Whatever record you wish to make, go right ahead.
Okay, so before we get going into the record making, just with regard to these issues, I do also think I need a clarification with regard to the prior bad act that was mentioned in Your Honor's order with regard to Angel Ritchie. It's my understanding that Angel Ritchie's testimony may be about an event unrelated to what the Commonwealth is proffering as the cause of this whole thing, and therefore they're not going forward with it, but I may be wrong about that.
Is that correct, Commonwealth? I saw that in the motion to reconsider as well.
If counsel's referring to
initial statement in the prior bad acts about incident where the defendant attempted to hug the victim, the alleged victim, and she started to hit him. I agree. We're withdrawn that in light of the fact that Angel did disclose to us that occurred well before the precipitating event of that affair.
With regard to the several prior bad acts that Your Honor is inclined to let in, with regard to the injuries that were observed by various people of Michael Ricci, or the proffered injuries, I think that creates a difficulty because...
Are you talking about the co-worker?
I'm talking about the three co-workers, I'm sorry, the two co-workers, other individuals that they're saying things about injuries. I understand Your Honor's position with regard to keeping the hearsay out. I agree with that. However, the injury comes in, we have a real relevance problem because those injuries are only conditionally relevant on some statement with regard to Christine's culpability in those injuries. And by not having the statement come in, which I agree it shouldn't come in, the only way they become relevant is if you invite the jury to speculate as to the cause of them. And it's not enough, I don't think.
Are you doing that when you know you're going to have testimony, or anticipate there's going to be testimony, from what I understand of the case, that the children witnessed those injuries and witnessed the black eyes as well? So I don't know. The devil may be in the details with regard to whether there's a temporal lining up, if that's known. But it does seem to me that the fact that other individuals that may have been seeing the decedent on a regular basis, weekly, daily, I don't know how often they work shifts together, noticed injuries, it is perhaps corroborative of the reliability of the testimony of the individuals within the household who have a more fulsome ability to testify regarding that. How is that speculative?
I do think that we can make a distinction between the people in the household that see injuries and the workplace. And I may have to make a bit of a proffer as I go forward as to what I expect the evidence to be. But what I expect the evidence to be is that in the two cases of the co-workers and Robert Higgins, his testimony, their testimony will be, one of them, that he doesn't work with him regularly. He saw him at a fire. They came to a fire together, and he noticed bruising on his face. And then there's a statement that Michael allegedly makes to him. The statement is out now, but the injury is in. And now the question is, in January of 2020, are we asking, which is very remote, about a year after and more, the observations of the people in the household with regard to a fat lip, which would have occurred at the end of 2018. Now we're talking about 2020. Him saying, the only reason that would be in front of the jury, and the only sort of reasonable inference they could draw, is that they're allowed to speculate as to the cause of those injuries, and that the cause, if it's in front of them, must be the defendant. And that type of call to speculate to the very foundation on which this evidence is conditionally relevant, is improper, and it's irrelevant in and of itself if it's taken in isolation. For example, the Mike McCarthy example. In the example of Michael Dillon, another person at the firehouse, he says he saw him with scratches on his face at various times. Those pieces of evidence, without any evidence with regard to causation, or invite the jury to speculate, and cannot be independently relevant, even if we have observations from a year and a half before, or 2.5 years before in some instances, of what the kids say they saw. And I agree, there's a difference between, and that's the Bianchi case that Your Honor cited. You have hearing things, seeing things, and then you have statements made immediately afterwards, or observations being made immediately after. That's a very different scenario than somebody shows up at work with scratches on their face. We're just going to put that in front of the jury and let them come to their own conclusion. And if the idea is we can just use the history of the relationship to sort of fill in that gap, that gets it exactly circular. Because isn't that exactly what we're trying to prove in the first place? We're trying to prove something about the history of the relationship, but we're going to let these unconnected statements come in, and we're going to let the history of the relationship do the work for proving the nature of the history of the relationship. It has to be conditionally relevant on something, and there's nothing in there in which to base it on. And so it's irrelevant without those things, and I think it's a real problem. In addition to that, with regard to they have to prove by a preponderance in all these cases that she's the actor. That's a foundational question for prior bad acts. The mere fact that he's coming in with injuries doesn't do that, and it can't get them there.
Well, the fact that they excluded hearsay testimony that the jury isn't going to hear, can't I consider that for purposes of them meting out their preponderance, even if I'm not allowing the jury to hear it?
Well, I think in ordinary circumstances, Your Honor can consider hearsay for the purposes of relevance determinations for admissibility. But I don't think that's true with conditionally relevant things. I think the nature of conditional relevance is it has to be relevant, conditioned upon already admissible evidence. And it can't just be put in front of the jury, particularly where it invites speculation, which is exactly what's happening here. Now, Your Honor may say, well, I've heard enough for me to be satisfied that that speculation is justified.
Well, I haven't heard anything yet.
No, but I'm saying your ruling entails the idea
understand.
that I'm listening to inadmissible evidence, which makes me, the judge,
Right.
satisfied that it represents something that is a reasonable inference. But in order for something to be conditionally relevant, that conditionally relevant thing does have to, I think, be admissible or admitted. It can't just be a free-floating thing out there. Now, also, very few of these injuries, such as they are, can even be placed in time. Like, for example, Mark McDonald's, statements with regard to injuries, Mike Dillon's statement with regards, well, his statements are a little bit more pointed in time. Those are the scratches. Robert Higgins' statements with regard to swelling. Those statements are all completely disconnected, so we don't really know when they are, but we know that, like, at least Mike Dillon's stuff is in 2020. It's far removed from these examples of violence that occurred, in the immediate aftermath of the affair. So what I'm saying is having it hang out there is dangerous. Having it hang out there invites speculation. And in and of itself, those things are irrelevant. And they can only be relevant if the jury makes some assumptions, and they can't do it. With regard to Robert Higgins, there are additional things that they're trying to get out through Mr. Higgins. And I think there are real questions as to what it is that he actually told them. I've read two separate reports in that case, in which in one case, he's confronting Christine with precise allegations or even broad allegations to her face, and she says something in response. In another version of the event, his statements with regard to Michael's injuries are 7
Testifying today.
He's on the list today.
We hope to get to him. He's towards the end of the day. Right. So there is a possibility, yes.
I want to do a balancing act here about certainly permitting the defense to make the you have, although I think you're fully protected by the motion to already filed. I'm trying to balance that with getting off and running in this case this morning. So, Attorney Wood, is there something that you, and I'm going to give you, I'll give you at the close of the day whenever you need it, at the side of the bench if we get to that witness today or at the break, whatever. Is there anything that you need to address this morning before we get going with the jury?
One clarification as to whether or not the Commonwealth is seeking to put in evidence of two Freeman. One is an event which they're describing, I think, as a suicide attempt. It's my understanding that Katrina Freeman is going to place that event in time and is going to place that event on May 10th, 2020. She's going to say that it was Mother's Day, and she's going to mention the children being home. Is that their intention? And if that is their intention, I would ask that at least the Mother's Day and children excised from that prior bad act in the presentation. That's number one. Number two, there's also an allegation made by Katrina Freeman at one point, and I don't know if they still intend to elicit it, with regard to a hitting event in late 2018 in which they're going to say that my client admits something and that she also suffered some personal injury as a result of it. My position is, if they're hoping to do that, hoping to elicit that, that we excise the part that describes Ms. Ricci's personal injury, and I can be more detailed about that if Your Honor wants to after the Commonwealth answers the clarification.
Okay, so do you only want me to address the last thing?
I only want you to address this last thing. Is she testifying today?
Yes, she is testifying, Your Honor. She would be the third witness for the Commonwealth today.
Okay.
And yes, we seek to elicit everything defense counsel brought up.
Mother's Day.
Yes, so the Mother's Day incident, Your Honor, I believe defense counsel is asking for perhaps us to be limited in saying it was Mother's Day and saying that the kids were home. The problem with that is that's not factually accurate, but also Angel Ricci.
What's not factually accurate? Was it Mother's Day or
no, if we say it was, I mean, I guess we could say just the date. Is that what you're looking for?
I don't know why we have to. We could say May 2020. I don't know why we have to say it was Mother's Day and the children.
What's the problem?
Well, because I think it invites.
What am I missing?
Because I think it's unduly prejudicial and it's not probative of anything.
Because it's Mother's Day?
Well, because the context in which this is going to be spoken is that the children were home and it was Mother's Day and the suicide attempt happened at that time in particular, and it invites the jury to judge Ms. Ricci with regard to things that are unrelated to this case, including her as a mother, which is deeply prejudicial sort of picture that's being put in. And if the issue is, if what's being to be proven by the prior bad act is something about the nature of the relationship and the extent to which the defendant was affected by the extramarital affair, which is, I think, the stated reason for it, it doesn't kids being home play any role in that evaluation, except to sub rosa of the defendant. And part of what that is what we talk about when we're worried about propensity. So yes, I think those two pieces of evidence, even if Your Honor has found that the event is probative, that those two pieces of the story are non-probative and are deeply prejudicial and clearly fail the 404B prejudice analysis and balance.
Your Honor, I believe that, first of all, it wouldn't just be Katrina that we're intending to testify about.
I imagine it's going to come in through the children that were there.
Exactly. Angel Ricci helped with the father to remove the knife from her hand. So he's right there in the thick of it. It's not just Katrina's observations. And the relevancy of it being Mother's Day plays into part of the statements we provided, that Katrina said she actually had been drinking that day because she lost her own mother. She came home to the Ricci house. She was especially upset because it was Mother's Day, and then sees this happening and says to her, I can't believe you're going to do this in front of your kids, basically on Mother's Day. So it's very much interconnected with the reality of what was happening on that day. I mean, I guess we could just say the date. We're not going to just say May 2020 because part of,
no, you know, I think it's not. Here's what I'm going to do, and you will reconsider it as the evidence comes in live. You can say it's May 10th, 2020. I think there's some import to the fact that the witness remembers the date, and that it's not some amorphous date in May of 2020 that this happened. And I'm going to reconsider as we go through whether or not the Mother's Day aspect of it comes out, particularly depending on how the cross-examination goes. But I'm not sure that I agree with the defense, the value of the Mother's Day connection, but it may be my deficit in knowledge of exactly what happened. So I'm not getting either the probative value of it or the prejudice of the fact that it's Mother's Day.
And the other problem I see with that, Your Honor, and I'm sorry to belabor this, is if, for example, defense questions her about the fact that she was under the influence when she made these observations, then it absolutely would be limiting the jury's knowledge of why she was under the influence that day, for example. And that was because she lost her mother, and that was a very hard day for her each year. We provided all this information to defense counsel. It's not a surprise. So I think that needs to be considered. And then are we going to now take away and not allow her to testify that she was under the influence, which would then be taking away evidence from the jury to consider whether or not to believe her because she was under the influence because it was Mother's Day.
All right, here, I'm going to put this back on you. I want to see some of the discovery. This could have been raised if you were really seriously concerned about the whole Mother's Day aspect of this coming out. It could have been raised. If it's been raised in discovery, I'll take a look at what the Commonwealth's produced, and I'll rule on it before we get her live on the stand. Anything else?
I think there was one other issue you wanted me to address, as he brought up the injury to her right hand following an incident that Katrina was home for. Didn't you bring that up as well?
Correct.
So I'm not sure if you could just repeat what the issue was. You don't want her, it's problematic for evidence to come in that she was injured as a result of punching him in the face?
Yes, particularly because my client has an unrelated joint issue and she wears orthopedic prosthesis in the courtroom, and so that is a particularly prejudicial thing to have in front of the jury, particularly when it's not needed. If the point of it is these people had a problematic relationship in late 2018 that led to violence, you have it already, because obviously we talk about violence, we talk about force. The focus is on the person whose force is being used upon, not upon the person who was using the force. So it provides no relevant or probative detail except as sort of this prejudicial communication to the jury. And I'm not suggesting they meant to do this, but with regard to the other issue, with regard to Katrina, it's very clear from the Commonwealth's response that that is exactly the type of presumption that the Commonwealth is hoping to make, talking about how difficult a situation it was for Katrina Freeman on Mother's Day, and to have Christine Ricci on that day attempt to take her life and to confront her with that, and then to be confronted with Katrina's statements about what she thinks of Christine as a mother, doing it in the home with her children. And to answer Your Honor's question about why it wasn't raised earlier, I felt very confident that that prior bad act was going to be kept out and was waiting to see the contours of Your Honor's decision. But even if I did not, I received that disclosure within, I think, 1 week of beginning trial. So I got that.
This trial date?
Yeah, well, the original trial date of, I think it was on the week of the 8th, July 8th is when we received Katrina, when they did their re-interviews of all their witnesses.
Not the last trial date. I mean, didn't you have it, well,
we didn't get that.
you didn't get it until,
we didn't get it until July. We didn't get it till July.
All right.
We didn't get it till July, or at the earliest late June, as they were preparing the witnesses in this case for right now.
All right, so we're going to hit the pause button. Get yourself lined up. We'll take it at the break.
Just so Your
Whenever
Honor
that
knows, we
is.
immediately provided a police interview of her, which was conducted on May 7th.
Of 2024?
Yes.
And that doesn't include all of the statements that came in as a result of the subsequent interview that was done by the DA's office, in which that full statement was developed. So this wasn't a question of me sitting on my laurels or letting moss grow under my feet. I just want to be clear for the record.
I had no doubt about that, counsel.
I think that's it. I think we should move on.
I think,
but I'm happy to provide the court. I think you wanted a copy of anything
That
we've
was turned
provided
over. Right.
the defense.
All right. Anything else anybody needs addressed that's pertinent to the next chapter, pre-charge or opening statements?
I think we're all set, Your Honor. Thank you.
All right. Excellent. Madam Clerk. Do you want a copy?
Is there a chance that we could have a quick bathroom break?
Sure. Just hold them at, line them up and hold them.
All rise, please. Thank you. You may be seated. I don't know where.
That's the being
Little thing.
Yeah, they look like all these.
Court, all rise. Court's now in session, please be seated.
May I approach just to hand Madam Clerk the information regarding Katrina?
Yes.
No.
Bring in the jurors.
Okay.
I don't know what's going on with this. They need to get a camera for this court. This shit keep getting blurry as fuck. We might have to switch back to this other trial, gang. This shit ain't looking good. They should be back by now. For hour break. Yeah, they back.
Court, all rise, jury entering.
Nah, we ain't even doing that right now. We going back to the Ashley Benefield trial, man. That's what we gonna do.
The lunch break, and before we bring Deputy Keelis or Detective Keelis,
I don't know how we doing it.
We had left off a bench conference with the defendant seeking to admit and then question Detective Keelis.
Bro, it's only one FedEx here.
Exhibit 3, which
where's the other
I will describe as.
So it's not here,
told
gang.
Me that these are.
This is what I'm saying.
From Ashley.
This is how I know when a nigga be playing.
And the printout is from Cellbrite, which the detective testified is one of the software packages that they use to extract and organize data and then put it in a readable format. I will note that in looking closer at Defendant's Exhibit 3, the report, the Cellbrite report, has a start time of August 29th, 2016, and a last activity of April 19th, 2017, and lists 319 attachments. However, Defendant's Exhibit 3 only encompasses August 29th, 2016 through December 3rd, 2016, and the page numbers are not sequential. That is, it's page numbers 1, 786, 222, 222, 2,222, 2,224, 2,233, 2,237, 2,240, 2,263, 2,264, and 2,266, although I'm assuming that's just because that's the relevant portions that the defense wants to get into. Certainly state, I'm sure you have these as well, and may...
Well, I guess one of the issues, Judge, is that we aren't being shown anything from the defense until Mr. Taylor's at the podium, and we have to ask. So I don't know what they're using because they've never filed a discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AB texts, but they're not all the same. They're some of the same. And so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to give it over to Your Honor. And I think we're kind of being sandbagged here because this continues to happen. What happened yesterday with Ms. Murphy, those were items never turned over. May I approach? If you don't mind. Thank you.
You've raised a much more fundamental issue. There was no defendant's exhibit, witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million
IA report, internal affairs report from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense. And the original witness lists were filed in the late June.
Okay. Probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the, the defense has 15 days.
I can enlighten Your Honor.
All right, please.
They attended a deposition of Sergeant Keyless where we had the specific text messages that the court has seen. They were clearly aware of them. We responded.
Is they arguing about this fucking video that's supposed to already come in?
Things was what we refer to as a phone dump, DUMP. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, searching. We treated them no differently, Judge White, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed. But at the deposition, I clearly presented these to Sergeant Keyless, and he acknowledged that they were part of what came out of this extraction through the Bright Line program.
All right, final thoughts? I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think Your Honor is well familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little, please?
I keep forgetting. Any tangible papers or objects that the defendant intends to use in the hearing or trial. It is disingenuous for this defense team to say they are using 391 items, many of which are inadmissible at trial. So, and obviously they didn't follow the dates. We're trying to move this trial. We do not want this case to be continued. We're continuing on the best we can. But now we've come to this point where there are things being offered for evidence that have never been provided to the state, that I can't even find at the same copy in what they provided. They never provided this, anything that looks like this. So that's the problem we're having. And the obligations are different, as Your Honor knows, and I think that they have not, in this situation, that's part of the problem the state's having, that we feel like we're a little behind the eight ball because their obligations are not the same.
All right, thank you both. So certainly the obligations under the Florida Rules of Criminal Procedure are different for the state and the defense. The state is required to list all information or witnesses that are relevant or material being calculated to lead to the discovery of admissible evidence. They've got to categorize witnesses A, B, and C, provide defendant statements and substantive statements. The defense requirements are different. The defense requirements would be turning over or identifying those witnesses that are expected to be called at any hearing or trial, and disclosing any documents that are expected to be used at any hearing or trial or introduced at any hearing or trial. It sounds to me like the defense got the phone dump and provided it to the state. Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any trial or hearing. But I'm not going to find that there was a willful violation of the discovery rules because it sounds like the defense provided. I haven't heard specifically. It may not be in the format that we're looking at, but according to the defense, they provided the dump from Cellbrite.
Well, and also, Judge, here's a copy of Sergeant Keyless's deposition of May 31st of last year, and these exhibits, proposed exhibits, are attached to his deposition.
All right.
Judge, can I just clarify real quick? The defense did not provide us a phone number. We provided it to them. They listed it and said it's in our possession. So they did not provide us a phone
Okay, so she already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation, though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing, and that also includes your list of witnesses, which I understand has already been done. I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent I think I can find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing. All right, so
We could just request that be done before we're in the middle of examining the witness.
And copies need to be shown to the state prior to showing them to a witness.
Of course.
All right, so let's get going on what we were talking about. That being Defense Exhibit 3, and we had an objection. So go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes. The court wants to take up now the admissibility as it relates to specific instances
of Exhibit 3.
Yes. Okay. So we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Ms. Benefield that can be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024 with a memorandum, use of discovery depositions and substantive evidence of criminal trial. I also had previously filed on July 10th of 2024 defense request for clarification reports amended on this road. And without beating it to death a second time, I cited the court to
You're not buying no views. Apologize.
Smith versus State, where the defendant was awarded a new trial because the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim. The Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's
Appreciate all y'all doing.
a
We're breaking down
first
two
district
cases
case, September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So, I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a second district court of appeal decision found at 290 Southern 2nd, page 73, goes back to February 1974, Your Honor. What was particularly interesting about this case is the second DCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol, immediately before the defendant shot him. I have to say, Judge White, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying and witness repeating, "My husband attacked me and I shot him," clearly beats the pants off of thrusting the hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Can I hear the citation again?
And I might remind the court, in addition to that, Miss Benefield had the scratches on her side and the swollen eye. Here is the Henry case, Judge. May I?
Yeah.
Do you mind?
290 Southern 2nd, 73.
And I have one as well. I don't know if they want to hand it up now. I'll read it.
This is what you just handed out?
Yes.
All right, I've reviewed Henry.
You want me to comment on Britain, case that they just provided?
I haven't read it yet. You can if you want, but I'll probably let them go first. All right, go ahead, State.
Judge, to be honest, we are still going through what they're trying to introduce because this is missing pages from the exhibit that they were talking about. So we don't have, I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overact, yes, regardless of how that's proven. I believe once that is proven, other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britain case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charge, and the speculative nature of any real connection whatsoever as far as any apprehension in Britain's mind. I do believe that even if the 911 call substantiates some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I could tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence. And I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So we would object at this point.
Sir?
We expect to call and testify a domestic violence expert. That domestic violence expert is going to educate the jury, in fact, he should educate all of us about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of the 4-year relationship, that is why the reaction of Ms. Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along. In the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse. And you begin to develop a survival instinct for it. So that's why you employ the get along,
It's
go
not physical
along.
abuse.
You do not want to do
She's saying it's
anything
mental.
to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that. That Ms. Benefield's concern, and the court may recall, it was the state that asked this question.
Mental abuse
Dr.
is tricky to
Quintal
me
was actually Benefield concerned
because it
about
all
the
depends on
release
how
of the
mentally
broker
strong you
report.
are.
Remember, Judge, I served it up
You feel me?
on the head of a pin.
If you are weak
The
mentally,
theory of the
the person will
state
be able to take
is
advantage
that
of
Ashley
you
Benefield
and do
killed her
things to you that
husband because
regular
the
person
broker
wouldn't be
report
able
was
to.
going to be
You know,
released 3 days later.
you just got to be built different.
Question, Dr. Quintal, by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record, she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify. I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions, some people call them spontaneous statements, and therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. In order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's an issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove, using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent substantial evidence, that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order, and this is, again, Smith, 606 Southern 2nd, 641, and this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing. 577 Southern 2nd, 682. And in that situation, the evidence was kept out and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights.
Oh, yeah.
The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm, or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd, 420. And this is at 422 and 423. It's first DCA 1996. And it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from 96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here and there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it, and I looked at Henry, I was reading Henry that the defense produced, to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge trial judge excluded evidence and unfortunately it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry, Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the
I guess you can ask, but I'm in the middle of a ruling.
Well, I think it may be relevant, helpful
Okay.
the court's ruling. I think what the court is saying is it's looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay. So.
Right, and that's what I'm making my findings about.
Yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us, would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 call, he attacked me and I shot him. The only thing I would say to the court is, to the extent Ms. Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt, and in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue, so I did the research. And this may be the case that ultimately, if it gets to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
Thank you. Just, Judge, for the future, if in fact these WhatsApp messages do come in another way, we would also be asking for the rule of completeness the rest of what was taken out the act.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
Right. So I just to put defense on notice that may be an issue.
So we're going to bring the witness back in, and you can resume your cross.
Run the jury in and out for naught. I've shown Suzanne the remaining aspect of my cross, anticipating there may be some objection to it.
And I would have an objection.
You do?
Yes.
Okay, can you step back out? Sure. Same rules.
Judge,
Yes, ma'am. The witness is out.
I'm trying to interpret this as fast as I can, but this, then maybe the defense can confirm. I believe these are supposed Google searches or internet searches for certain subjects that are on
Yes,
this
they're
Benefield
on
phone.
the phone,
And
that of which was extracted by this witness.
there are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Can you give the judge the date of those?
The first one was, I'm sorry.
2020, Your Honor.
The first one was 5/11 of 2020. That was the ask Amanda, how do I co-parent with an abusive, or the parent with an abuser. The next one was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent
Yes.
by Doug Benefield, which says, for the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord. Romans 6:23.
Yeah, that one was shown by the state. They just moved past it a little quickly.
So, Judge, I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this coming out.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Keyless extracted. First of which is on May 11th of 2020, and the subject is domestic parenting with an abuser.
I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Perotta's report. A few months before the shooting, searching the internet for how to co-parent with an abuser, and then again on 5/11/20, ask Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project. And 6 tips on 5/11/20 to help you co-parent with an abusive ex. So, the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the predicate. Once the 9/11 tape came in, which said my husband attacked me and I shot him, together with the swollen eye and the scratches, as the case law says, I think that may certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing a murderous...
You said I excluded them? I did not exclude them.
You're not allowing me to introduce them.
I said not now,
No,
at this point.
Okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
You're admitted. Now I find myself in the same position, except now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have, in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. But again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think, at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. I've told the court several times now, that's the whole
Appreciate you for tapping into the stream.
MO of an abused woman is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Miss Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response?
State response.
Judge, the reason this should not come in is the exact same reason that you just ruled on last issue. There are other reasons if it becomes relevant, if it becomes admissible, but that would be my reason now.
Could I please see the exhibit?
Of course. May I?
Yes, sir.
And the purpose of offering Defense Exhibit 4A is to prove that Ms. Benefield actually made those searches?
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Keyless went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
previously I had made the ruling that the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came, the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone, and the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. We still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a certain day. And so it's an out-of-court statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay.
Yes.
So at this point, I'm going to rule that they're not admissible.
Rule that sucker in.
I have no further questions of Sergeant Keeler. I would like to make a proffer, if I could, for the record.
Of course. Do you want me to call him back in for the proffer? Or are you just going to proffer?
No, I'm just going to read Defendant's Exhibit 2.
Dang, here you go.
Anticipated Exhibit 2. These were
What did he
text
do?
messages that were downloaded by Sergeant Keeler.
Judge, can we just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
But if we could just make a copy and enter it in.
Oh, we already have an Exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as Exhibit 2.
That's the text messages.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, Exhibit 3. I marked it as Exhibit 3, the text messages, and it did not make it in.
Okay, got it. Yes. These are text from Doug Benefield's phone to Ashley Benefield's phone, downloaded by the officer.
Correct.
Right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes. Composite.
State, for purposes of the proffer, do you believe that
Keyless.
Detective Keyless would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
I believe he would. Judge, I don't know specifically with the second exhibit, specifically because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes, sir.
Do you want Keyless to stay under subpoena? Because I want to give him the right instructions.
Yes.
All right, can you have Detective Keyless come back in? I'm so focused on getting his name right, I keep forgetting his title.
Judge, if it makes you feel better, it took us about 2 weeks to get it.
It just looks nothing like
so
that.
different.
That's why I did it.
Sergeant, I'm sorry. Just right in front of me. Sir, at this point, the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is being out there on the internet, you are not to watch or listen to anything related to it, including news reports. Do you understand?
I understand.
All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you. Oh, hold on. All right. Look, the clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
text message,
the What's Now apps, WhatsApp messages. All right, that's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A; it's 4A, 4B, 4C, and 4D. So we have
the
composite 4 with A, B, C, and D, and then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want?
Well, I'd like to have it on there because they showed it, but they showed it very quickly.
Oh.
Defendant's Exhibit 5, which is
Yes.
one of the I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in. Thank you, Madam Clerk, for catching that.
Well, it's
right. 5 is in. 3 and 4 are proffers.
When you say, Your Honor, that Exhibit 5 is in, for purposes of proffer.
No, for evidence.
Yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible.
No, I'm ruling 5 is admissible.
Okay.
Because it was shown. State, you showed it.
Right, it was shown.
So this is just a printout of.
Okay, but I think he hasn't. Do you want it admitted?
The witness is gone.
So maybe 5 should just be with the composite number 4 and not entered. Just be as a problem.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I don't know what its status is then. All right. All right, say you ready to call your next witness?
Yes,
Ready to bring the jury in?
Yes.
All right, let's bring him in.
and I think we are going to use I know you just opened the blinds, but.
welcome back. All right, you all can have a seat. Welcome back, everybody. Did anybody begin deliberations amongst yourselves, talk with anybody outside of the jury about the case, or do any research, or hear anything about anything you talked about?
No.
All right. When we were last here, Detective Keelis had finished his testimony, and now we'll let the state call their next witness.
Stay with call Dr. Vega.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Hello, sir. I'm Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It just does adjust up, down, left, to right as you need. Speak in a loud, clear voice. We should hear everything.
I will. Thank you, Your Honor.
Good afternoon, doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the chief medical examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an associate medical examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please, yours.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a chief medical examiner, or at least, yes, as a chief medical examiner?
So as the chief medical examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
And so that was my next question. The percentage, you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And I'm going to draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
Dr. Vega, I'm showing you what the pre-marked states 86 through.
Can I see the photographs, please?
Yes, they're the same as the ones you just when you look at that.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
She's going to put them back in order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length, as that's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the length?
The body length was measured to be 69 inches, or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you. Sorry, Judge, just bear with me. Dr. Vega, we're going to try this one more time. I'm going to show you 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
Yes, I do recognize them.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you. Your Honor, at this time I'd ask to enter states 86 through 97.
No objection. Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them up here in just a moment.
Okay.
Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
Okay. And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Oh, okay. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in States 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. The chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you States 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in States 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you States 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to States 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's been pre-marked as States 14. Would you take a look at that item and tell me if you recognize it?
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter States 14.
Objection received.
And Doctor, I'm going to show you States 95. Is this the same projectile that you have there in States 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and where where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance wound would be?
Certainly.
Thanks, sir. And where would the exit wound be?
Well, no exit. But
I'm sorry, the projectile.
The projectile,
Yes, sir.
my mobility is a little limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
And you said that the wound was front to back. Was it, and from how you showed, you said it was essentially horizontal?
Yes.
It wasn't front to back like it went straight through. Can you describe it?
Certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral.
His vertebral body.
Thank you.
The spine.
His spine.
Yes.
And would that injury have been immediately fatal?
Probably not.
And would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes.
And how so? And this, for the record, states 91.
Yes. What one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then you said, finally, you said he was also shot in the leg. Is that correct?
That's correct.
Okay. So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation-wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's excuse me, the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it, the calf area.
And the chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different.
And how so?
Because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently that defect in the skin is paralleled by a defect in the tissues that one can appreciate underneath. Many times the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast-moving awl or punch, in that it goes in and it almost drills a hole into the skin, but when it exits, what it does is it tents up the skin until the skin tears. That's how a bullet exits. So typically, the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 that correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And I have a close-up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf. And then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect, injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out, and that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can. It's easier. Yes, sir.
Hard to see with the here, so.
Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
So on me, the entrance was down here.
If it help, I can put my finger there.
Okay. And the exit here.
So here to here.
Yes.
And so that's, you said slightly up or up.
It's upward from the right toward the left, and from back to front. Yes, largely all three of those components.
Thank you. Well, you know what, Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that I made you get off the stand.
Entrance. Lodged bullet.
Would you just spin one time? Just turn so they can see. Thank you. Thank you so much, Dr. Vega. I appreciate that.
Mr. Taylor, were you able to see both of those demonstrations?
Yes, Judge White, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you States 15. You'll take a look at that and tell me if you recognize it.
Yes, I do.
And how you recognize it?
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter States 15.
No objection.
Received.
Thank you. And Dr. Vega, I have a photo of States, this is States 97. Is that the same item that is in States 15?
Yes.
Thank you. Did you find any, I'm going to go back to the, well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
Well, the absence reflects the same principle in either injury, and what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle. So would that mean that if it's not necessarily the body of the shooter, but if they had their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel and we're still talking about the leg injury, for this leg injury, but does it tell you, this path of travel, anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated, because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And, Your Honor, may I have just one moment?
Yes.
Dr. Vega, if hypothetically Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
If this injury were sustained while he was falling,
yes,
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell, when you conduct an autopsy, and specifically in Mr. Benefield's, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes.
And was that done in this case?
It was.
And was there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular, and so when they're damaged, they bleed very quickly. And also there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Yes.
I don't have anything else, Dr. Vega. Thank you. The defense may.
Mr. Taylor Cross, and of course the question is, do you need this?
I do not.
Yes, sir.
Afternoon, Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice, thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct, yes.
Muscular build.
I don't think I used that terminology. I think I just talked about the weight and the body length.
I want to ask you, you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, that's, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3 foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection, Judge, beyond his expertise.
I'll allow it if the witness has the knowledge to answer.
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay. In simple language, it could be excusable,
Objection, calls for legal.
I'll sustain.
justifiable. I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because that's asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
Let me just check, Your Honor. I think that might
Yes, sir.
conclude. Last question with respect to the leg. You've told us that the gun would had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Vega.
State, any redirect?
Yes, Dr. Vega, I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him. It entered through the side.
Yes, so the weapon did have to be in front of him, but even more so it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running, or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Oh, Judge, while we're switching, could the deputy pass 14 and 15? Would you mind?
Oh, pass, you mean
Yes.
to the jury?
Sorry,
I wasn't
publish.
quite sure what you meant.
Sorry,
Publish.
I meant pass through the jury. Yes, sir.
All right. Members of the jury, as with yesterday, we're going to pass these around. These will go back with you during your deliberations. All right, State, your next witness.
Daniel Hausdorff.
My gang, my squad, my crew, my gang. Appreciate y'all. We're still rocking. For sure.
Madam Clerk.
We're gonna let this rock out. Then we're gonna jump back
Do you solemnly swear or
to
affirm
the
the
Christine
testimony
Ricci
about to
trial.
give the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
So later, we might talk about, well, before we start the gaming, we're gonna talk about Netflix cutting off subscriptions in the US.
It does adjust up, down,
Random.
left, right as you need.
Just
And
random.
Just speak in a loud, clear voice, it should pick up everything.
Yes, sir. Thank you.
Good afternoon.
Good afternoon.
Could you state your full name?
I know y'all wonder,
Oh, I'm sorry.
why is
Go
he
ahead.
sweating?
You all finish up.
I just had to tear the carpet off the floor.
I apologize, Judge.
Trying to figure, am I
I don't
gonna
want anybody to
stain
feel
the
rushed.
wood floors
But like I
or
said, everything
recarpet
will
it?
go back with you all during the deliberations.
Thank you.
All right, Ms. Friel.
Thank you, Judge. Please state your full name and spell your last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorf.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the firearms section.
And how long have you been in that position?
I've been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test fire the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say cartridge, well, we're going to get there, I'm sorry. What kind of training did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearms section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst and completed the 18-month training program to hold that position, and have been out of training since August 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but an intact live round.
Yes, ma'am.
Okay, so you use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as?
A projectile.
Thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases from firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And so the cartridge case leaves the firearm every time?
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number?
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab where it's given a unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I receive from my supervisor when I'm assigned the case, and that has all the details of the case. and everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence, where the custody of all the evidence is being held at that time, and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Armory 45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FTLA case number, item number, and my initials and my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block. All are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
Yeah, it's empty.
Oh, I was going to say there's gloves here if you need them.
It's okay, sir.
Again, Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
Mr. Hausdorff,
Yes, ma'am.
would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip
I
of the
can't have
firearm.
firearm.
At that point, I would release the
It's a nice
slide
gun.
and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a
It's
spark
crazy.
to go through the
To
flashlight.
do my
and then
probation,
the gunpowder,
I wouldn't even
which is
know
gonna
what
cause
I'm
this rapid
talking
expanding
about. This
gases
shit.
to propel the bullets
You're
down
not
and
supposed
out
to
of the
have
firearm.
nothing to do with
But it's
firearms.
also going to cause the slide to move rearward.
Nothing.
The fired cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm.
We
and then
do
go back towards the
trials.
gun, pulling another cartridge from the magazine
can
and
cover
into
that
the
shit.
chamber of the firearm, ready to fire again.
Thank you, sir.
I'm sorry, Mom. Can we put it for a moment?
Of course.
Today has been more of a like a fucking. Let me see something because this volume on this shit is crazy. It be seeming like it peaked every time I fucking talk. But yeah, it's been more of a chill day today. I got a lot of shit going on, you know. Oh yeah, this shit turned out way too high. I put on like 80. I'll turn this up. Dang. Now we're not peaking. Hello. For sure. But yeah, man. We back and shit. You know?
Mr. Hausdorff, if we heard
Been
testimony
more of a
that
chill
when
day.
this firearm was found,
Not too much. I ain't
the
interrupting
slide
a
was
lot.
not totally
Just
seated,
letting them cook.
does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And that the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
And if it were not seated and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are
Oh, bro.
Your
Her name
items
is
3
Christine Ricci.
through.
That's what's fucking me out. I'm like, this can't be the actor. Can't be
Take a
the
look at
actor,
state 4
bro.
through
Not
7.
Yellow
Tell me if you
Jackets.
recognize them as items you previously examined.
Christine. Apologize.
I messed up.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FDLE case number, item number, and my initials in my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed in which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test to test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just
Yes,
so we can
ma'am.
talk about that part?
Yes.
We're really going. And so you said you first look at test to test, and can you explain slowly
Yes,
what you're looking for to compare those, to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you looked at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you.
Apologize. Her name is
I want to now show you
it's not Christina, it's
states
Christine.
8, 9, 10.
It's Christine. Christine.
And 14. Would you like to take a look at these items?
Yes. Thank you.
And tell me
I think
if there are
I'm
items that
upgrade
you
my mic.
previously seen in your lab.
This shit a little iffy. This shit a little iffy right now.
Yes, ma'am.
And how do you know?
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullet as well as the weight. And if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact, so I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in .45 caliber class.
And that's the same caliber as the casings and the firearm, is that correct?
That's correct.
And what type, other than the weighing the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
No, I think the first time you said fired in, and then you said fired from.
In a
The
minute.
reason I just say in is the cartridge cases are
I gotta take a
technically
run.
in the firearm, and I
When
say
I
from
get
because
back,
the bullets leave.
We're going to go more in depth.
And so there's really
into
no
this Christine
difference other than
Ricci
it's
trial.
technical.
Yes, ma'am.
Thank you, sir.
We're definitely going to go more in depth.
Finally, I want to turn your attention to States 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but
Take it
on the
into it.
container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that it was no value from microscopic comparison because it was too small and there was no individual characteristics or rifling seen.
So you can't make any determination, could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received one T-shirt, and what I will do is I will visually, microscopically, and chemically test the T-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create basically a sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the T-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I wasn't able to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This is States 2. Is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
And I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
Gunpowder.
Thank you. And when you examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations, that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual T-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment?
Yes.
I don't have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross.
Very briefly, so Mr. Hausdorff, your testimony here today is basically that the ammunition was fired from that gun in this case.
Yes, sir.
And you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
Peter,
No, sir, thank you.
can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're released from your subpoena. You're free to go.
Thank you, Judge.
Thank you. State.
Your Honor, at this time, the state rests.
All right. Members of the jury, the state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm going to give you 15 minutes. So remember, please don't discuss the case amongst yourselves. Please don't do any research on the people, places, things, or legal topics we've heard anything about. Don't speak with anybody else outside of the jury about this case at all. All right? Leave your notes. All right, you all can have a seat. All right, when I just sent them on an afternoon break, I could see some worried looks on your faces. It's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea before I let them go for the day. I saw the looks. All right. So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument. So we got to get through that. Now, depending on what the ruling is on that, we also, if I do deny it, I'm going to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the colloquy that I go through. I'm looking back through my notes. We've still got the issue of Vicki Mechanic, trial sub, and Richardson hearing. We've got the issue of Daubert and what's his name? Bliss, the expert. Ferris. I don't know where I got Bliss.
He's a police officer.
You smushed them together.
Okay. We've got that, and I have another Richardson issue. It just says 391 emails. Okay, Richardson emails. And then we also have the issue of Faith Brown. And she wasn't listed, but you want to call her to authenticate those emails, and I would assume put her own
To impeach.
her own explanation for them,
Yes.
which would be inconsistent with the testimony Ms. Murphy gave.
Yeah. And there's one other matter.
Oh, all right.
In an effort to protect Ms. Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday, so I've already heard from Ms. Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay. Well, I guess we'll eventually just kind of wait and see if her presence is obviated by Ms. Brown's testimony. I don't want to make assumptions.
I understand.
So, we're going to kind of give you all the option. If you want to, I can give you the break that I'm giving them. You all can talk about
Do we want to do some more work tonight? How late do we want to stay? Do we want to get all the way through this? Would it be better that we took care of some of this in the morning? Because I don't know when is Mr. Ferris going to be available?
I would anticipate when we decide to call them, they'll be available.
Okay.
Yeah.
All right.
I think we could do the JA, Your Honor, and the other stuff. We could do the JA, and maybe if you want to do the discovery now. I certainly wouldn't mind breaking a little early. I would guess that would be fine with them also.
Can I stop you? When you say JA, I think judicial assistant.
JOA.
JOA. Okay. I just want to clarify.
Sorry.
Thank you.
Well, yeah, I think let's at least get that done this evening.
Yes, okay. That was gonna be, I was trying to figure out if you meant JOA or JA.
Yes, sorry.
So now,
That's the reason why breaking early probably would be good.
right. So let me give you all a break.
Thank you.
Absolutely. When the jury comes back, I'll let them know that we have some work to do on our part. We're not leaving early. We've got stuff to do, and then we can hit the ground running tomorrow morning. Just so you know, because it's as soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that. But I will have a hearing at 8:30 because I've got motion for release of uncharged defendant, a 33-day motion. I'll have to hear first thing if it hasn't been obviated by the filing of the information or a null pros. I don't know yet.
And that's scheduled for 8:30?
I set it for 8:30 tomorrow. I asked for it to be set for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you.
Yes, sir.
It's never easy, Your Honor. We have a witness issue. Faith Brown is available now, but she is not available tomorrow. She will not be a long witness. I wonder if the court would entertain, however Your Honor wants to do it, while we have the jury here, I can call her. Or case law even says the Supreme Court case of State v. Smith, the court could call her as a court witness. And when she's done, then we could do the JOA or we could do it in reverse.
I'm sorry, did you say she's here?
She may be outside now. She was on her way over.
I would at least like a few minutes to speak to her based on the fact that I didn't know about her.
Yeah, of course, I'd absolutely give you that option. So that may, and certainly based upon the case law, certain witnesses and facts and evidence are going to have to be presented before, not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the state. That's the other subject of your Richardson hearing, is those emails from the sealed hearing that we've now had access to. I think had to have been obtained by the defense from his Faith Brown, and because the state's never gotten those until yesterday.
What was the date, September 30th?
Judge, those emails came from the state.
You're going to have to show me where, because I don't look at my.
Well, we don't need the back and forth. I'm trying to figure out.
I don't know.
Listen, this is for me, who typically is just, let's start the trial, let's go, let's get this thing done, not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done, what do you think about we make tomorrow a work day? I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be an outstanding idea.
My first one of the trial.
No, that really would work out pretty well because I got witnesses like planes stacked and my head is spinning over it. So, yeah, that would...
And just so you know, State, this is also what I'm contemplating is the fact that whether or not I find any kind of Richardson violation for the emails or whatever the other one was, I can't remember what the other one was, then you have the entire weekend to go through everything. And we kind of hit reset, and then defense, you can come forward with your obligations. If it's a witness you expect to call, a document, a tangible object you intend to use at a hearing or trial, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me, but what do you think?
And Judge, I would be fine with that. My only concern is that I thought some of the alternates had conflicts next week, and I don't remember, and maybe it was actual seated jurors, I can't remember.
No.
There were conflicts that started next week,
but I don't know
I'm not sure what they were.
Started Monday or Wednesday or.
I think the juror that the gentleman we had last today, he has a conference starting Monday out of town. Not that we would be done tomorrow.
Judge, I can only tell you that for my purposes, I believe I could have pretty much, even though I had some problems, I think if we hit the ground running Monday morning, I think I can move this thing pretty good.
Right, but does that mean finish Monday or finish Tuesday?
Oh, definitely
Define
don't,
finish.
definitely don't finish Monday.
All right, so defense case done Monday. And then
Then we
you,
close Tuesday.
and then you,
That'd be the-
I think that might be optimistic. I think Wednesday probably is more realistic.
Okay. Just
right, so
saying.
finish defense case Monday, but then we have jury instructions.
Right.
Oh, can't. I apologize, sir.
Okay.
So you expect to finish Tuesday?
I hope to finish Tuesday. I didn't mislead the court when I said I had a number of witnesses. I will do my best to end it on Tuesday, but it's going to be challenging.
Yes, I mean, you're correct in identifying that some of the jurors expressed that they had time restraints, but however, both sides chose to keep them.
Well, and I think what would Wednesday on the calendar be?
Next Wednesday is the 31st.
I think we still should be okay. I know for me, I had some scheduling issues at or around the 1st. So
right,
we can try to finish the case up Tuesday, if not early Wednesday.
Judge, I just think if we're talking about the defense not even being done on Tuesday, I don't want to take a whole day with nothing. I mean, but I recognize that I would make the final decision, but that would be my opinion, is to not go a full day without doing any trial tomorrow. But
all right. Do you have some witnesses, defense, that you could call tomorrow afternoon?
just one.
Yes.
All right. So what we could do is we could do some work this evening. Again, depending on what my ruling is on the JOA, we come back tomorrow morning. Oh, and I checked, the information is filed, so I do not have the hearing at 8:30. But we can start first thing tomorrow morning with these hearings that we need to get through. Go to lunch, and I tell the jury to be back here at like 1 o'clock, and then we start the defense's case in chief around 1, and go as far as we can. Okay?
Okay.
You're nodding your heads, but
Yes, sorry.
Okay. All right, so if you could, let's bring the jury back out. I'm going to release them for the evening and ask them to be back at the jury assembly room tomorrow about 12:45 with a goal of having them up here around 1 o'clock.
I'm sorry, Judge. I'm wondering where does that leave me with Faith Brown?
Call them Monday.
Well, if she's not available tomorrow,
She's not. Is she available Monday? No, she's out.
I'd say maybe call her Monday.
Yeah, that'd be fine. I can do it. I just want to make sure she's available.
Sure.
Yeah.
Right. Is she under subpoena?
No.
Judge, I just feel like the state doesn't have the option to say our witnesses are not available. I mean, if they're traveling or the next morning or whatever, but to delay an entire day because they didn't make arrangements with their witness, who they haven't listed, seems outrageous.
No, hold on.
Okay.
This is me, because I want to get these, I got a bunch of hearings that I got to get done, including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we can just call her Monday, and that'll give you a chance to get a deposition done. Did he step out to ask? What's he asking?
You want me to put it right?
No, I just need to know, is that the plan?
Yeah.
So, because I want to let the jury go, tell them to be here tomorrow at 12:45.
He's out there asking her now. And if there's no chance that we can put her on today, then.
No, I agree with the state. She hasn't even been listed. So I certainly will allow you to call her because I understand the reason why you need her. But I think the state, again, hearkening back to that due process concept, they have a right to speak with her and take her deposition.
Okay. Can you give me a moment?
Of course.
I'm happy to report, Your Honor, she will be available tomorrow at 9 o'clock. She's got a little window, so we're good.
All right.
So we're going to do up motions this afternoon?
Yeah.
Thank you, Judge.
Yep. And hopefully she's available for you to speak with her. Do you want to step out and make those arrangements now?
Yes.
But while you're doing that, can one of you stay?
Yes,
and I'm going to tell the jury 12:45 tomorrow? Well, no, wait a minute.
Right, now we have to have them here in the morning.
Now I need them here in the morning.
Yes.
Okay, all right. Hold on. I just want to make sure she's going to be available. Because you guys have every right and should be able to speak with her about her expected testimony. Did that come up during your conversations?
It might come up, but I'm sure she'll talk to them, Judge.
Go ahead.
I don't know, it's not committing college. Well, Your Honor, I feel like a vacation has been snatched away from me.
The what?
I feel like a vacation has been snatched away from me. I was picturing having a walk.
Road & Track says the Mazda CX-50 offers a superior driving experience, distinctive styling, and a cabin that punches far above its segment. What we'd love to know is what you'll say.
New Alka-Seltzer Fizzy Melts. Fast fizzy relief of occasional heartburn. Wow. No water needed.
Judge again, and in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times. And the entrance wound of the fatal wound is not front. It is side to side. So he was turned away from her, and then it's the state's argument that he was moving his leg to run when he was shot as he's running away. She then just leaves him there to die and runs away. And Judge, I think all of these things together, in the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor. So a lot of the things that defense just argued have not come in as evidence. So in the light most favorable to the state, we would ask you to deny the JOA. Thank you.
Mr. Taylor, would you like to place any rebuttal in the record?
Very briefly. Thank you.
Or not briefly?
Yep, no, briefly. So here's what we have according to the state. We have a woman who is going through a divorce, who has no prior history of criminality or arrest, who, according to Broder, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing a report after report, not doing anything but staying in compliance is what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from
somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and you go from there and killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want him to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick. I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed, and failed miserably to rebut it. And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said, yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right. Thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
No.
Okay, all right, I just want to make sure. So, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief by a preponderance of the evidence. I don't find support in the law for that, and I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think, based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal. you're going to see Ms. Brown. I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the Richardson, you're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
Was it, I might be mixing apples and oranges. Something was 390 and something was 316.
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing. And so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked, and he showed me the part that was missing, and based on that part missing, I will go back now and try to find it. So
what is it, a header or something?
Yes, it was the top of an email.
The auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. But the heading forwarding it to her was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is?
277.
277 on their exhibit list. And it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies or at least clue me into where it is and what exact pages are intended to be entered, and that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that there would be to solve, I can hopefully do that in the future before we have any more testimony about these. But that I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been put on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and then just to be safe.
Do you want to do it now?
Yes.
All right. So the issue is a discovery violation by the defense, and I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be the substance of my argument.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified
But
something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents. So I without verifying that, I would take that as true based on that representation that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my objection or my allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at the trial.
All right, do you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of the doubt that the testimony was wrong. So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony, that can't be right either. So we have to find the happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. But I will tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
Yes, Judge. I think that is, I'm trying to find the right word. On July 16th, Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said, on page 4, I have an envelope to seal this, if necessary. I have Ms. Murphy's stand your ground testimony that I will pass to the court.
You might need to slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking. That was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at the stand your ground. So to now say he had no idea that she would do this, which the state finds offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word. Because it's clear from your hearing that he did, and Your Honor asked him, was he turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing to the state. So the state feels like this wasn't intentional. They had a hearing with Your Honor that they asked for it to be private. And although they said it was about Vicky Mechanic, they're the same emails. It's the same email chain. And so the state feels that it was an intentional violation. Thank you.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are. This is not supposed to be a surprise or a gotcha state. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said, I don't think ultimately the Richardson framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had, and whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Ms. Murphy and Ms. Brown as meaning different things? Could it be received by the jury to be substantial in their decision making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are and what you need to do, and you must comply with that. You must identify witnesses and list them that you intend to call at a trial or hearing, and also identify those documents or tangible things that you intend to introduce. More so than these 12,000 or whatever the number was documents, we could pull something out of there. I think the obligation is different, and I agree with that interpretation of the rules. The final analysis is the prejudice, and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different? Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently. But just at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there is any prejudice. So that's my findings on the Richardson hearing regarding the emails. I had down that I was supposed to do another Richardson hearing. Was that the only one?
It was about Faith Brown because she was on the list.
Yes. Okay. Do you want to be heard on that?
Can we just have a minute? We were just discussing it. Judge, we've decided not to ask for a Richardson hearing on Ms. Brown. The state's concern was that, along with these emails, that it feels a lot like sandbagging to the state, or trial by ambush, as I think your judge, as your honor called it. And that was our concern. But in the light most favorable, in our mind, to the defense, we'll assume that they realized once that Ms. Mechanic couldn't be called, then they listed or they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought Ms. Mechanic could be called.
Now that you've had it, and you don't have to respond, now that you've seen my order that has been unsealed, I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes, sir.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir.
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email, you never authenticated it with her. You never laid the predicate. And I was waiting and waiting and waiting. So I think she's available to authenticate it, and I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening. Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing on calling of Ms. Brown. So hold off on mechanic subpoena for now. The argument about it.
Yes.
Okay.
I think so.
I'm just going to put that on the back burner for now.
I suspect that's going to be resolved.
We still have a few minutes. I would like to, at a minimum, read my colloquy to Ms. Benefield regarding defendant testifying. I typically will do this in a trial. I'll do it early on, but I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
If it does, Your Honor, I would ask that you
skip that
respectfully.
Fair enough. No, let me look. I don't think it does. All right, Ms. Benefield, listen closely. This is what you're going to hear me say. It might be tomorrow, and then I'll tell you the questions I'll be asking. It might be Monday. I don't know. One of the most important and fundamental constitutional rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you, just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions will be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs, you understand what you're doing, you're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended, I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client trusts that I have her best interests at heart, and I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making a choice after consultation with her attorney. And this is just piling the pressure on the client. I'm sorry, Your Honor, I find it uncomfortable.
You wouldn't be heard for that. I mean, it's my decision.
I would like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it is not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes the decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm going to tell you what I say, and if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me, so if you say, hey, don't answer that, okay. But I'm going to have it on the record, because in the future, if anybody says, oh, I didn't know, I thought I couldn't testify, my lawyer told me no. I mean, the plethora of cases that are out there, I think that case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll ask, make sure that nobody's threatened you, forced you, or coerced you to make this decision, that nobody's promised you anything, any benefit or a particular outcome to make this decision, that you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you were aware of it, and if you decide not to answer any of those, that'll certainly be your prerogative. So we'll have that, like I said, we'll have that. I want to let you know about it, and then we'll have that conversation either tomorrow or next week. All right, anything else? That was everything on my list.
I have one matter about an ex-party brief discussion I had with the court, and I supplied the court with some case law to support my position, and I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response.
All right. Well, I think whenever you had approached me about this case that you gave me the other day, ex parte, without going into the details, my answer was, I think that the state has every right to be heard on this request. So I will leave it to you. Do you want to talk about it?
Fair enough. Can you give me a moment?
Of course, absolutely.
All right, Judge White, we're good. Request withdrawn.
Okay. All right. Anything else we can talk about today? No?
What time are we starting tomorrow? 9, she said that.
Where'd my list go? Let's shoot for 8:45, just in case there's any last minute stuff. And then with the goal of starting at 9.
And is the plan then to have testimony all day?
Yeah, I think so.
Okay.
Right? We're gonna have them lined up one after another, ready to go?
Pretty much.
Okay.
Okay.
All right, we'll be off the record until tomorrow morning.
Thank you, Judge.
Company out window was spent 40 pounds of candy bars. What is this? Don't make this better. Someone, please help me. No, Ryan's got a flag. Stop saying it's so weird. Well, flag is just the one. Never. Just don't slip the light. What's next, man? One of these fighters gets out of here. Let me pass. Come on, you can believe this, Spirit. Almost there, Jackie guys. I don't step around the corner. I can smell it. See? Oh, wow. Look how much people are running. Please do this. Please do this. Come on, man. I'm the medicine right here. You really slow it on bubble back. What? I'm going to die. I'm not going to fly. Oh, where? I'm with Hey, Mr. Lloyd, what word is always spelled incorrectly? Is it Hermanander? Nope. No, it's Hermanander? No. But get up! What word was that again? The word is incorrectly. What? The word again? Seriously, how about my head? Hey, hold up! I still don't know what the word is! Oh, it's time to address me. Don't take it personal. Everything's about you, alright? Just stop showing up. We're not riding in your car, no matter how cool it looks. Ready to go? Ready? All right, let's break it and get the truth. Why didn't you say anything? You're scaring me. This turns long. No, it's not. I dare you to ever come back again. Oh, Jesus. You're cutting off the window. Don't worry, just a small problem. We can totally fix it. My car! Okay, special prayers, line up with people calling. Chicken, check. Husband, check. Bicycle, check. And finally, doctor, check. Yeah, look, you're supposed to be on my side. How can you betray me? Really? I can have a version of you here to my enemies. You have a version of you talking about not going to go. We got it back up, Jordan. Whatever. Are you done? He's obviously not that much more. But he's saved me. There's gonna be more to this. Maybe he's making some serious problems. You guys won't come with me. It's going to come. This is where I'm going. That's not even stupid. You're being... He's been messing with something. I need to tell him something. The truth I always knew. Actually, I'm not the bad guy. I'm the one who is fucking Richard's crew. Those ranks always happen. That's the best part of my life. One day, I'll just skip down and somehow will realize eventually. I know that now the very takes the better is doing terrorists now playing at regional lines in a factory. What's it in the world? Unfortunately, it's a common of dawn and not together cold. What's the plan to ensure painless money minutes for all the skill? What a big one is my crown. So I built it to stand, not to be explored. It's very I need to protect the quality. That's what happened. Oh, Captain, you give it up too much. I'm killing you to make you pay for this. What are you doing to me? Just moving this Captain to my orders. Getting easy out that fun. Get finished off the words like statue. Waiting to flow what you think. Just a big misunderstanding. Let me explain. Everything's clear now. Why waste time so you betray my trust? The smiling prayers of God. Your job is long. Time to pay the price. You're a psychopath. What you want and loyal was you who held first. Don't survive. I'll be quick and clear. It owns your skin. Not the statue. There's this grand captain. I love that right there. Another responsibility to you. Prototype, I'm with all your evil plans. I'm here to save Captain. Don't think God, he's crazy dangerous. Come fight me if you dare. That stupid dog, think your teeth are tougher than my steel? What's next? Perfect. I'll bring you plus to go first. Call them. Today's gonna be up next, everybody. Prepare, Gary. I know it's late. Our family, so you keep talking. Just back to Grant. Grant, now go. You. Boss, get Grant behind you. Look at the tears. Here's the antidote, dude. Why didn't you give it to me sooner? Saw you working hard, so I guess I figured I didn't understand. I want that doctor. This isn't one to keep coming back. What now? does me, I'm gonna die. Oh my God, this thing's a good-year-old charged up. Why did I enjoy it so much? I'm a vampire. I'm gonna be the one who kills his friends and drinks their blood. I'm gonna dress up like this. This will scare the smiling critters away. They'll be safe and live. From now on, I'll be living in a silence and confidence. And I will be happy forever and ever and ever. If you were a real vampire, you'd be dead by now with this month. But you're still alive, so let me tell you the full story. Oh, no way, I should protect them myself. Yeah, let's just go ahead and see it. Where's danger? Nobody for you. Guns took them out. Seems like that we were going into this horror story. She's getting close. Maybe we can find some clues. Why? Maybe he's hiding something. Something he's doing that to avoid everyone. Whatever the place is, we need to find it ASAP. Interesting. Hold on. Why not come? I've got you for you. Okay, you're invading my space. You think I only put cameras in your room? Come on, there's everyone's room. That's right here, there's no such thing as privacy. But why did I feel so much better after drinking Vinny's blood? Smart move. Just make sure you're looking at meds, okay? What's wrong? It's just potato chips, not blood, girl. So, that means a little vampire light. I don't think I can stand anything, Rick. How much stuff do we still have to get right? Dinosaurs and caramel. We got some good job. Maybe we'll use it for a while. I'm tired of being left off that. Is that what we have to do it? Please do.
Shit just got rude. My fault, man. Listen, we got one more to get to. I'm gonna let it rock. Shit, we're gonna late. I know.
Want to trade Bitcoin, plus oil, plus gold, plus so much more? Let me introduce you to...
I'm not letting it rock. No, start over. Oh no, we're not doing that. We're doing that.
Intended to touch Mr. Ricci, Michael Ricci Sr., and forth that the touching was not justified.
It was just gonna die for sure.
Let me move on now to a few logistics of the trial.
I'm gonna let this
itself,
rock
and
for a
let me
minute,
first
and
address
then we jump.
note-taking.
When I get back up
jurors.
here, I'm just going. We jump
At
on
the end of the trial, when you meet privately to deliberate, you will have all of the exhibits that are admitted as evidence in the case with you. We cannot provide you with a transcript of the witness's testimony, however. So you're going to have to rely on your own memory of what each witness tells you. You may take notes during the trial if you wish. Our court officers will give you a notepad and a pen or a pencil. Some jurors find it helpful to take notes while they are listening to the evidence. It may help you focus on the testimony and remember what the witness said. Some of you may not want to take any notes. That's equally fine. Whether you take notes or you do not is entirely up to you. But whether you take notes or you do not, you need to pay close attention to what's happening in the witness box, what each witness says, and how they say it. In your decision-making, you will decide who and what to believe, and you need to watch and listen carefully to what's going on in this witness box so that you can make those decisions. Think about whether the witness seems believable, whether the witness's memory seems reliable, and anything else about how the witness testifies and what the witness says that may help you decide whether and how much to believe that witness. When you deliberate at the end of the trial, remember that it's your memory that counts. Your notes may help jog your memory about what a witness said, but they are not a substitute for what you and your fellow remember about the testimony. Do not assume that because you or another juror wrote something down, that it's more accurate than your or another juror's memory of what the witness actually said. Your notes are confidential. No one, including me, will read them. The court officers will collect your notebooks and pens at the end of each trial day and keep them safe and secure until they're returned to you the next morning. When the trial is over, the court officers will destroy any notes that you did take. Let me next talk about your comfort. If you have any trouble hearing or seeing anything during the trial, please raise your hand and let a court officer know, and we'll make the necessary adjustments. It doesn't often happen in this courtroom because the jury, it's a new courtroom, and the jury box is readily accessible and viewable from your spot. But if it happens, let us know. As you know, we generally take a morning break at 11 o'clock and lunch from 1 to 2. Because we got a delayed start this morning, I'm going to adjust that morning break. We will have a morning break. It'll be brief, and it'll come closer to the lunch hour than it will on a typical day. If you need a break at any other point, you just let me know by raising your hand, court officer, inform the court officer. If you need to communicate with me during the trial, please let a court officer know or give a court officer a note to bring to me. I want to go through those cautions again. By the end of this trial, you'll be able to recite them along with me. They're important, very important. These are the things that you need to do and that you may not do during the trial. Keep an open mind throughout this trial. You must not decide this case until you've heard and seen all of the evidence and listen to my final instructions at the end of the trial. Do not discuss the evidence or this case with other jurors until you start your formal deliberations at the end of the trial. This is because it's hard to keep an open mind if you start talking about evidence and testimony in the middle of the trial, so none of that. Do not talk or communicate with anyone else about this case until after you've reached and delivered a verdict, and I tell you that you've completed your jury service. This is because, as I told each of you when you were selected, you must decide this case based only on a fair consideration of the evidence and the law, and must not consider any outside information or opinions. When I say that you can't communicate about the case until you've reached a verdict, that means you can't do so in any way, including through your cell phone or other tablet device, computer. So until you reach a verdict, you may not text, chat, email, tweet, blog, or post anything about this case using social media or electronic media or anything else. You have to wait until the trial is over and you've reached a verdict before you say anything about this case to anyone else. You may not talk to the lawyers, the parties, or witnesses during the trial. If the attorneys or other trial participants see you and they affirmatively turn away, they're not being rude. They are simply following my rule, my order, that they not speak to you during the trial. During this trial, please do not read, watch, or listen to anything about this case that may appear in any news media, social media, or any other source. If there is any press coverage or other coverage about this case, you must ignore it. Do not do any research or investigation about this case, online or in any other way, or have anyone else do that for you. Do not visit any of the places mentioned during the trial. Do not Google or search names of people involved or participating in this case, or Google anything else about this case. Once again, this is because you must decide this case based only on the evidence in the law. The rules that I just explained to you are very important. I'll keep reminding you of them at the beginning and end of every day, and I'm counting on you to comply with them. If anything happens that seems to be inconsistent with these rules, please do not discuss it with your fellow jurors. Instead, let a court officer know, and I will speak with you privately. So jurors, we're coming to the conclusion of these preliminary remarks that I make to you. Jurors, I know that you will try this case according to the oath that you just took as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that law and approach this case with an open mind and make your decisions fairly and without any prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, whatever that verdict may be. It's now time for the opening statements. And as is the custom, well, first of all, I'm going to have you all rise, jurors, and shake up. Whatever you need to get your focus back. You will find, as I have now found in my years on the bench, that sitting is more challenging than it looks. If you need at any point to get up at any point during the trial, sort of the people in the back row have an advantage with regard to that because you can stand up without impacting anybody's sight line. But it's critically important that you're paying attention and that we have your full attention. So if you find yourself not being able to get your full attention, try to do something to rectify that. And if it means raising your hand, and asking for an unscheduled break. That's perfectly fine. What's most important is that you're paying attention to the evidence and evaluating the evidence silently to yourself. All right? You may be seated. It's now time for the opening statements in the case, and the custom is that the Commonwealth goes first. ADA Buckingham.
Good morning, ladies and gentlemen. It's been a few days for some, so I just wanted to begin by reintroducing ourselves to you. My name is Shannon Buckingham. With me throughout the course of this trial is Jeremy Kuzman and Jason Haran, and we represent the Commonwealth in this case. In this case, you're going to hear about Christine and Michael Ricci. The Riccis lived in Marshfield. They have 3 kids. Angel is the oldest, and Angel is not Michael's biological child, but you'll hear from Angel that Michael was his dad. The middle son is Michael Jr., and the youngest child is Sophia. And you will hear from them during the course of this trial. You're going to hear about Michael. Michael grew up in Hyde Park. Michael was a military vet. He spent 22 plus years with the Boston Fire Department. You're going to hear about the defendant, Christine Ricci. She was, for all intents and purposes, a stay-at-home mom, but she also taught Zumba, and around the time of this incident, she was taking classes at Quincy College. The Ricci family was a seemingly happy suburban household. But, ladies and gentlemen, we never know what happens behind closed doors inside a household, do we? You'll hear throughout the course of this trial from people inside the house and outside the house about how the Ricci household changed over the course of time, how the defendant changed, how Michael changed. You hear about the major turning point in their marriage that occurred in the fall of 2018. Michael had an affair. It was a brief affair, but it was an affair with another woman. And the defendant knew or found out about it. For a short period of time, the decision was made that Michael was going to leave the marriage, possibly leave the household, but quickly the decision was made for them to stay together and work on their family and stay together as a family. Michael messed up, but from the time that he told the defendant about the affair, he did everything he could to try to make things right and keep his family together. He worked on himself, he went to AA, he worked on his relationship with his children and his wife. He did everything his wife asked him to do. The defendant, on the other hand, continuously talked and focused on the infidelity for over 2 years. For over 2 years, her inability to get over that affair increased. You will hear testimony throughout the course of this trial from witnesses about verbal and physical altercations by the defendant against Michael. You will hear witnesses describe how the defendant would control Michael. They will tell you about seeing black eyes, fat lips, scratches on his face, and a broken nose. You'll hear that the night in question, January 28th, 2021, is not the first time the defendant brought a knife to an argument. This affair was like a pot of water simmering on a stove. And over the period of time between 2018 and January of 2021, the defendant continued to turn up the heat on that pot by bringing up that affair over and over until that simmering pot of anger, jealousy, and control boiled over on January 28th, 2021. So January 28th, 2021, it's a wintry Thursday. There was still snow on the ground. Michael was home that day. You will hear that his work schedule was a work 24 hours on, get 2 days off, work 24 hours on, and get 4 days off. And so on this day, Michael was on the 4-day stretch of having some days off, so he was home. The defendant was home. Their daughter, Sophia, had gone to school and was home in the afternoon. Angel was at work that day. And during this period of time, Michael Jr. wasn't actually residing in the home, but he was close by and available. On this particular afternoon, Michael goes to Dunkin' Donuts in the afternoon, gets a coffee, comes home. He's doing some shoveling outside before coming into the house, meeting the defendant, his wife, in yet another argument. The children will testify and tell you that arguments were frequent in the household and that arguments were always about the same thing, the affair. On this particular day, Sophia will tell you that she could hear her parents arguing when she was up in her room after school, but that was pretty much normal for her at that point. On this particular day, it was particularly loud, and she did everything she could to try to tune them out. Until later in that afternoon, when her mother, the defendant, yelled her name, yelled for her to come down. Sophia comes down the stairs, goes into the area in between the dining room and the living area to find her dad on the floor and the defendant standing over him. The defendant tells her to call 911. Sophia calls 911. You're going to hear the 911. You're going to hear Sophia's testimony about what she recalls that day. The Marshfield police arrive at their home on Moraine Street. They're the first ones to arrive, you'll hear. And when they arrive, the defendant tells the first officers that Michael suddenly collapsed. So the officers that arrived begin to tend to him by giving him CPR, and almost a few minutes later, paramedics arrive from the Marshfield Fire Department. And they take over care of Michael, continuing with CPR, trying to resuscitate him and get him in a condition to take him to the hospital. When the paramedics put Michael into the back of the ambulance, they, again, try to stabilize him. And it's at that point where the paramedics discover, after cutting away his shirt, that Michael has a stab wound, a deep, penetrating stab wound in his chest. When they remove the clothing, you'll hear, they find another injury, another wound to the rear of his arm near his shoulder. The paramedics immediately advise the police, who are inside with the defendant, and it's at that point, and only that point, you'll hear, that the defendant tells the officers that she had been in an argument with her husband, with Michael. She tells him she was scared, she grabbed a knife to scare him, and that when he lunged at her, the knife just went in his chest. Throughout the course of this trial, ladies and gentlemen, you're going to see those injuries. You're going to hear about those injuries. You're going to see pictures of Michael, how tall he was, how big he was, where those injuries were on his body. You'll hear that there's more than one stab wound. There's two, but there's in fact 3 injuries that are noted on his body. The stab wound to his chest, the wound to his shoulder or the back of his arm, and what will be described to you, I expect, as an injury along his back. You will see that there were 2 knives located in that house that day that had Michael's blood on the blade. The first was located on the floor by where his body lay, where he was laying when first responders first got to the scene, and one in a box on the dining room table with several other knives. You will see pictures of those knives. You will see pictures of the house and where those items were located when the police were at the house that particular night. You will hear from a medical examiner in this case more about that fatal chest wound and what the details of that wound, how deep it was, what kind of injury it caused, what damage it did to Michael's body, and what resulted in his death. We ask, ladies and gentlemen, that you listen carefully to the evidence and keep an open mind. And that's something you're going to hear us say, you'll hear the judge say, you'll hear everyone say it again and again throughout the course of this trial, but it is paramount in this type of a case, that you listen carefully and keep an open mind. And that you not forget that you, as a group, bring to this case your common sense and life experience when you evaluate the evidence. And we ask that you do that as you continue to listen to the evidence in this case. And the evidence will tell you what happened in the Ricci household that night on January 28th, 2021. At the end of this case, we will return and ask that you find the defendant guilty of murder and assault and battery with a dangerous weapon, because the evidence will prove to you beyond a reasonable doubt that she is, in fact, guilty of those crimes.
Thank you. Next, we'll hear from the defense. Attorney Wood.
Christine Ricci never intended to kill Michael Ricci on January 28, 2021, and the Commonwealth doesn't have any evidence to prove that she did. The argument that occurred that was just described to you, the confrontation that was just described to you, all of that information all happened during about a 15-minute, small 15-minute pocket between 4:30 and 4:45 on January 28, 2021. And every answer to every question that we have about Christine's intent, Michael's intent, Michael's last actions and Christine's actions are contained and sealed in that 15-minute pocket. And ladies and gentlemen, that's probably why the Commonwealth is going to spend such a small amount of time talking about that 15-minute period, because they want to distract you. Christine's words are really the only evidence that we have of what occurred during that 15-minute pocket. And those words, remember, were spoken in the moments after all of these events happened. It's true that she doesn't give a complete statement of everything that occurs, and as we go through the evidence in this case, and when I come back and talk to you at the end, I'm going to suggest to you, through reference to both the forensic evidence as well as putting together the statements, about what probably happened around and between the details of what it was that she said. When the police arrive, the evidence is going to be that Christine Ricci is absolutely beside herself. Absolutely beside herself. She is crying, she is heaving, she is hyperventilating. The first responders come to the scene and she can get almost nothing out. She says he collapsed, that comes out. The Commonwealth wants it to be the case that that means that she told some sort of misleading statement. The evidence is going to show that she gave an incomplete statement and that maybe she wasn't in a position where she even could give a complete statement. She was just too upset. After Michael Ricci's body is removed from the house out to the ambulance, there's going to be evidence from an officer by the name of Chris Martin, who's going to say that at that point they sat her in a chair and they asked her what happened. While the body is still out at the ambulance, while they're so-called discovering the stab wound that you just heard a moment ago. And the evidence is going to say that when she's confronted at that moment about what happened, she gives a little bit more detail, but she's still extremely upset. She's so upset, in fact, that she actually takes some medication to try to calm her down. But as she begins to say the details of the case, she mentions the knife, and she mentions the argument and the fact that it escalated. And that's going to be supported by the testimony of Sophia Ricci, who heard that escalation of the argument into a screaming match. And it's true, she does say, I held the knife out, and then at another point she does say, he lunged at me. And at another point mentions being attacked. And I'm going to suggest to you that the evidence will be that even when Christine said those words, that wasn't everything that happened. And at that point, the evidence will show she may not have had a complete memory of what had just fully occurred. But Christine Ricci's words are the only direct evidence that you're going to have about what happened between 4:30 and 4:45 p.m. on January 28, 2021. They're the only eyewitness reports of what happened. And they don't at all support the story that the government just told you. And that is probably why they are going to spend the entire case discussing things that didn't occur during that period of time. I expect that they are going to parade a bunch of witnesses in, remote friends of Michael Sr., who are going to be allowed to offer their opinions about the defendant. that they're going to pick along a 2.5-year period, a series of isolated events, and try to string them together to create the most damning possible picture of who Christine Ricci is. And that they will do so because they hope that you will be so distracted by the question of whether Christine Ricci is the type of person that would commit this crime, that you'll forget that the real question is whether she actually did it. As I say, at the end of this case, we will hear forensic evidence. We will come back and we will tell you a little bit more about what happened in January 28, 2021, in the absolutely critical 15-minute period. Talk about the mechanics and what's suggested. And a lot of it will be inference by inference, because we won't have that type of eyewitness testimony beyond someone's statements that was very, very affected by what had just happened to them. But what emerges from that is a very, very different picture altogether. Now, the Commonwealth wants you to tell you these stories about the past and about the affair. And it's true, there's going to be a story about an affair, and it's going to be a big part of the Commonwealth's case. This was an affair that took place in 2018. And a lot of the events that they're going to talk to you about physical confrontations, happened within just a couple of months of that event, maybe anywhere from a 6-month to 9-month period after that event. You're going to hear about other events that happened in the subsequent year and a half. Things like Michael going to AA, Christine supporting him in going to AA, him getting sober, him getting counseling, Ms. Ricci getting separate counseling, them going to couples counseling, them reaffirming their vows in Hawaii in 2019. And you're going to hear from all of the children, and although they're going to say that there was fighting still and there was a fair amount of marital discord, they're not going to describe the type of events that were occurring in 2018. But the Commonwealth wants to sort of string these things together from 2.5 years earlier to try to pretend that that says something about Christine Ricci in 2021. I'm going to ask you not to be distracted, to focus like a laser on the relevant period of 4:30 to 4:45 on January 28th, 2021. And I want you to be extra vigilant every single time the Commonwealth tries to distract you and talk to you about ancient history and tries to tell you about who Christine is and why you should believe bad things about her, and focus on what do they actually know about what happened on January 28th, 2021 between the hours of 4:30 and 4:45. And if at the end of the day, what you're left with is, I just don't know what happened, which is exactly where they are, then I'm going to ask you to find Ms. Ricci at the end of this case during closing not guilty.
Thank you. I'll seek counsel at the side of the bench.
Not gonna lie to you. You else with me? GC game. I ain't been on there. What's the shit they had on the my tablet? Everywhere they get on Warzone multiplayer match. Listen, I haven't bought it for the computer. I'm gonna keep it real with you. G shit. Now listen to me carefully. Listen shit where you can wrestle with these fucking. They gonna get my money to them. Promise you. Promise you. Just. Oh no. I ain't even not playing shit. Okay. Yeah, I might have to buy that. I don't want no team. I don't like going around. Be real. I'd rather die on my back. Oh yeah. There go my boy. Yo, listen. I'll be back. You dropping tomorrow? Yeah, if y'all fuck with that GTA RP. My shit about to drop tomorrow. Be real. That Blaze, word of my baby. Fuck with the town, bro. That shit was lit. Word of my baby.
Close one.
Oh, so that shit lit tomorrow. Alright. I'm with it, buddy. I'm with it, buddy. God, is lit. So tomorrow, oh man, I got kids. I was about to say once in our GTA, but I got my enemies dropping into the AO. Right, man. Oh, you got me. Oh, they got me. I ain't even see my boy jump in the jack. Either.
Enemy soldier incoming.
Shout out to everybody on my Rumble, YouTube. Motherfucking Twitch. No, I
All stations, this is Shadow 01. Deployment to the Warzone has been authorized. Enemies are...
I ain't even just put RP on here. I'm fucking other one. You know what I'm talking about? For sure. Okay. Okay.
Resurgence. Survive the timer to secure redeployment.
Earn
Earn points to speed up the countdown. Enemies dropping into the AO.
Hostile counter UAV overhead.
Ready for you, gang. Oh, I had that low ass machine.
You're back on station.
Played myself.
Go get after it.
Nah, you know me, bro. I'm an all Smitty.
Enemy buy station incoming. Gas is inbound.
Enemies deploy the counter UAV.
Stand by for redeployment. Enemy soldier incoming.
Hostile mosquito is online.
You got a loadout drop inbound.
Close one.
Enemies dropping into the AO. $25 are left. Stay sharp out there.
Oh, like the silence.
Gas is closing in.
Wrong gun. Bro, that's a shotgun.
Hostile advanced
Oh,
UAV
she kicked
overhead.
her.
Fire sale active. Buy station prices have been reduced. Resurgence is about to end. Make it count. Gas is moving.
Hostile counter UAV overhead.
Fire sale's over. Adjusting prices. Be advised, enemies deployed a buy station. Resurgence has been deactivated. This is the end game. Only 10 left. You're losing ground. Move it. You got gas moving in. You're in the top 5. Bring home the win.
You shot. Shoot the peak.
Oh boy, only 5 remained. You were close. Failure ain't fatal. It's just an opportunity to do. Well done. The threats are still pouring in. Let's get you out of there.
Live tomorrow, gang. GTA RP. Shit, gonna be live by 5 o'clock. So you tap it in, tap in. Come on. We'll get that blaze shit. Come on. Shout out to everybody on YouTube. Up at the brown, bro. That's alright. What the fuck? Freaking, is that a handgun?
Enemy soldier incoming. Check your gear and weapons. We'll be deploying shortly. Enemies are dropping into the area. Watch the skies. Enemies dropping into the AO. All stations, green light. We are deploying to the war zone. Resurgence. Survive the countdown to earn redeployment. Secure kills to speed up the timer. Hostiles deploy the mosquito.
I was chasing other dudes, man. Call me slip.
Resurging. Go get your revenge. Enemies are dropping into the area. Watch the skies.
Hostile mosquito is online.
You're getting another chance. Make it count.
What? What?
It's a valiant effort. Keep your head up. Return to base for debrief. 24 enemies active. Kill them all. You got gas moving in.
Hello?
Fire sale is active. Buy station prices are adjusted.
My fault, chat. Fucking daughter fell off her bike. Gotta get in daddy mode. Yeah, they clap me up. Clap me up, clap me down.
Check your weapons, check your gear. We're holding for deployment. Enemy soldier incoming. Enemies dropping into the AO. All stations, we are good to go. Stand by for deployment. Resurgence. If you stay alive till time expires, you've secured redeployment. 4 points you earned, faster that clock's gonna tick. Enemies are dropping into the area. Watch the skies. XP boost inbound. Location's marked. Hostiles deploy the mosquito. Deploy the counter.
Damn.
Get ready. You're redeploying. Hostile mosquito is online. Enemy soldier incoming. The enemy
Oh, through the wall, man. Through the wall, gang? Through the wall, gang? Belt to me. Belt the ammo.
Gear up fast. We're about to get evil. Enemies are dropping into the area.
Yeah. It's good already. Got something for you, game. It's alright. Drilling is out. You said he want to go to Walmart?
Prep time's over. Now you deploy to the Warzone.
Oh wow. Do they sell them shit at Walmart? $4.45. Cause it's just that 3-prong shit, right?
Resurgence. Survive the timer to secure redeployment.
They might sell it. Cause it's like the razor scooter charger. They might sell it cause it's like the razor scooter charger. Yeah, I ain't gonna lie. I be hating to talk with these headphones on because you should get echo to me.
Enemies dropping into the AO.
I be fucking on when I be talking. But I need this shit for Call of Duty though. That's a fact. He might talk to you in 3, cuz. He definitely gonna give me the whole 7 days. You hear me? Brody out here playing. I told you, Brody. My boy be the one to talk himself out of it. I can tell you, Brody. Brody tried to blame me for that. It's not a thing. God. Why? Why is she trying? Can't see you coming. Y'all about to come in the house. It's over. Y'all can't be outside. Erica scratched her brother. Now I gotta see if I got a whooper. Little shorty out here tripping. Huh? Yeah, it was outside. Eric just ran in the house talking about his sister just scratched him in the eye.
Gas is moving.
Some nigga appreciate that, Scott. Next time, come with some better guns. And bring a Claymore. You know what I'm saying? No, I was talking to you niggas on this game, buddy.
Enemy soldier incoming.
Yeah, man. He ran the door, cause played himself.
Loadout drop headed your way. Got intel on a new target. Counting on you to take him out. $25 remain. Solid work so far.
Hostile counter UAV overhead.
Gas is inbound.
Hostile advanced UAV overhead.
Enemies dropping into the AO. Lost your chance on that one. Target is down. Special orders rescinded. Resume normal operations. Fire sale active. Buy station prices have been reduced. Get ready. Resurgence window is about to close. You're losing ground. Move it. Fire sale done. Prices are back to normal. We are returning you to the front. Earn this. some bitches next time.
Chat. I'm out here telling mad jokes. You hear me? You ain't hearing none. I ain't know the mic was off.
We're headed to the war zone. Get geared up and stand by.
Listen, man. That nigga, you know it's my game, right?
Playtime's over. Stand by for deployment to the war zone.
For grown.
Resurgence. If you stay alive till time expires, you've secured redeployment. The more points you earn, the faster that clock's going to tick.
LZ marked. Follow me to battle. Close one.
Plenty of time left. Help yourself to another bounty.
Alright.
Hostile Guardian has been deployed.
He said it's just so many of y'all. Shit.
Time for vengeance. You're redeploying.
Listen, he played a major part in everybody's life. For sure. Literally. Oh, ski.
Get ready. You're redeploying.
What you trying to get? And where you want this at?
Gas is inbound.
Oh no, this sounds like a process. Sure. Oh man. Everybody. We can get it done though. Yeah.
Friendly loadout drops on the way. Primary objective complete. All targets eliminated. Bounty contest. Found your target of opportunity. Good hunting. Only 25 left. Keep up the good work.
Fuck me. I'm looking at this fucking gun.
Target is gone. Stolen out from under you. Stand by for redeployment.
Baby lane.
Gas is moving. Enemy soldier incoming. Mission's over. Returning to normal operations. Fire sale is active. Buy station prices are adjusted. Resurgence window is ending. Watch your six.
How is that possible?
We are returning you to the front. Earn this.
Yeah, I'm already bored. Halfway on the phone.
You got gas moving in.
Where does
Less than 25, we're still standing. They hit us hard that time. Let's regroup and get back up there,
Yeah,
yo.
I ain't seen Johnny in mad long. What? Yo, listen. What got Johnny talking about? What got Johnny talking about a tattoo, buddy?
Adjusting prices.
What got Johnny talking about a tattoo, buddy? What got Johnny talking about a tattoo, buddy? Cause I'll do it. But listen. It's a fact. Yeah, Mark. I forgot y'all niggas is cousins. I forgot y'all niggas is family. Yeah. Oh wow.
Check your weapons, check your gear. We're holding for deployment.
So they the older crew. That's wild.
Enemies dropping into the AO. All stations, green light. We are deploying to the war zone.
Oh, the white lady. That's crazy. Yeah. How you tell a nigga he ain't got no birth certificate? man. That's crazy. Yeah, that part. Oh. Fuck me, gang.
Resurging. Go get your revenge.
That part.
Enemies dropping into the AO.
That's crazy.
Enemies deployed a counter UAV.
Fuck me.
Time for vengeance. You're redeploying.
That part.
Hostiles deployed a mosquito.
Gas is closing in.
Yeah.
Online. Hostiles deployed a mosquito.
You got a loadout drop inbound. Bounty contest. Special orders coming in.
Oh, that thing looking
Locate and
crazy.
eliminate the target.
Dang, she got the butterface? Look at me like that. Oh wow, a little laggy, a little laggy. A little laggy got me. A little laggy got me.
You're getting another chance. Make it count.
I need them guns back though. I already told you what it is, brother. It's quiet. Oh shit! I jumped into it, nigga. Artist. Hey. Ole. Y'all feel me, chat? They can't fuck with us though. They can't fuck with us, chat. Oh shit. shit! Run, nigga! It's the same nigga. He in there hiding.
You're back on station. Go get after it.
Yeah, buddy. Or just, yeah, I'm over here fucking niggas up. He said what?
You're losing ground. Move it. Enemies are dropping into the area. Watch the skies.
That's how I usually be though. Type shit. It just look good for the movie type shit. Fuck.
Windows closed. Back to standard procedure.
This nigga sound better.
Fire sale active. Buy station
Okay,
prices
okay,
have
okay.
been reduced. Get ready. Resurgence window is about to close. Gas is inbound. Fire sale's done. Prices are back to normal.
Blood clot. Oh.
Hostile mosquito is online.
Be advised, resurgence is no longer active. This is for keeps.
Ain't even know.
Occupation scan. Avoid enemy surveillance by staying low
Nah, we
or
don't
using
play
the
with them.
water for cover.
Nah, I had a wild life.
Enemy surveillance active. Get to cover. Enemy operators
Yeah,
tracking your
fucking
location.
right, bro.
You are one of 45 remaining.
That's
It's a
crazy.
valiant effort.
Persuaded.
Head up.
Straight.
Return to base for debrief.
I mean, that's what have it.
You're losing ground. Move it.
Brody can't hit you, buddy. Why you want to rub it in his face right now? See? 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 Then he gonna blame it on me. Nigga said, if you wanna jinx me this morning. Nigga, what? Did nothing of the sort. You know what I'm talking about? Sure. Yo, gang.
Gear up fast, we're about to get evil.
I was about to turn my first command. Uh-oh.
Playtime's over. Stand by for deployment to the war zone.
Expenses, buddy. Trying to tell you. Kids fucking each other up, bro.
Resurgence. If you stay alive till time expires, you've secured redeployment. 4 points you earn, the faster that clock's gonna tick. Time for vengeance. You're redeploying. Enemies dropping into the AO.
Nigga ain't go to work. On his day off, buddy. Nasty work. Trying to tell you what happened, buddy. Brady said, I ain't fucking with no job. I ain't messing with these people. They ain't give me what I want. I can't leave when I want. I ain't fucking with these niggas. And he got up out of there, buddy. Damn, blood.
Friendly recon.
I gotta be like that, though. Definitely got the Ray Charles shades on. Oh, you trying to play me, cuz?
Be advised, UAV is exiting the AO.
You trying to play me, cuz?
Hostiles deploy the Mosquito.
Enemy buy station deployed.
Boom, boom, boom.
Friendly recon overhead.
Gas is closing in. Be advised, UAV is exiting the AO.
Really?
Hostile Mosquito is online.
Friendly Guardian is active.
Damn, blood. Damn, blah. You said you built like an old nigga, guy. Nigga said my daddy, guys.
That's how Lethal canceled that.
You made the top 25. Well done. You got gas moving in.
Yo! Oh shit, blah. Oh, he got me, blah.
Resurging. Go get your revenge.
Uh-oh. Uh-oh.
Fire sale is active.
Rot him.
Enemies are dropping into the area. Watch the skies.
I don't know. Oh, he clipped me. He saved me.
We are returning you to the front. Earn this. Resurgence window is ending. Watch your six.
What? Damn, blah. Fuck that kid up, God. Alright. Bless your heart, Kenny.
Gas is moving.
Bless your little heart, Kenny. That's crazy, blah.
Counter UAV overhead. Hostiles deployed.
Oh, last shot. That was crazy. You know what? Cool.
Stand by for redeployment.
Oh, your little cousin got shot? So I tell your little cousin to get back. What's wrong with him?
You got gas moving in. You're in the top 10. Keep knocking them out.
Dude, I ain't gonna make it.
Hostile Mosquito is online.
Gas is moving.
That's crazy.
Battery low on the Mosquito.
Only 4 remain. Finish the job.
I did that shit on mistake.
Gas is inbound.
Oh shit. Yeah.
Finish your mission. Take them down.
Close one.
That's a win.
Let's get it.
What's yours?
What you talking about? Got that W, buddy. Wait for this bitch ass nigga.
Close one.
Close him down. I ain't even had no mask. Ain't good enough.
Fine work, but enemy reinforcements are streaming in. Let's get you back.
Y'all ain't check the websites? Oh, that shit don't come out till tomorrow, do it? Oh yeah, I'm gonna check that website, that 123 movie shit. I seen that shit on the that shit decent. W's. I only call 4 about it. For sure. You say is what it is, buddy. That's crazy, blah. You're supposed to treat yourself, not beat yourself, you are. That's what I'm trying to tell you. Be a man. Get some hair on your chest, gang. You know what I'm saying? Assalamu alaikum, my nigga. Salaikum salam and all that good shit. You alright? Hear me, gang. Alright. In the chat. We got that fucking W. We got that W. Yeah. Got that W, chat. That fuck 'em up. A minor. That shit crazy. Aquarius. This sound like some nigga I know. We call him Quay. Luchadora? She ain't even got her backpack. Why she ain't got her backpack? She's supposed to have her backpack. Give them up. Let me use the bathroom real fast, okay? What are we talking about? Let me check this real fast. What are we talking about? I appreciate everybody that's still tapping in. Used to be at that W. That's what we do. I was about to start the first Ascendant, but I didn't. I'm about to figure out if we want to play that or not. You know what I'm saying? But yeah, man, you should be still getting these fucking W's out here, man. Put them W's in a shitty bang. You know what I'm saying? So we getting fucking W's, nigga. I'm just checking some stuff real fast. these guys want to chat and I'll be right back. Yo, bro, my mic been off this whole time, bro. My mic been off this whole time, bro. I've been sitting here talking, bro. Alright. Is that happening tomorrow? We doing GTA RP. GTA RP being Blaze. You feel me? Actually, what I really want for people to do, download 5M on your CPU. Download 5M. Look up Blaze. I think it's V2. It's V2 when you look that thing up. Jump in there. Actually, it's gonna send you to the Discord. Holla at my boy. My boy gonna get you up in there for a fact. Listen, man, I'm mad I gotta start my shit over. Had a little skyline and shit. Blicky on me. You know what I'm talking about? I got in this goofy ass accident. Slow me down, man. Slow me down, man. But yeah, we about to alright. I don't know what we was doing. But we here though. Push drop. For sure, for sure. He got his heart on the wrong side. Men's over here. Women's in the middle. So is this nigga what? Oh, they got me. They got me. Say word, they got me.
It'll be fine for a while, all right? I'm alive, thanks to
Yo.
you. And you even found time to...
I be getting zoned out with this shit. Keep it real.
How did I manage to get the slip on Ederlick?
I don't know.
He retreated as soon as the battle at the mining site was over
Good
and
job.
headed toward a facility. It looked like he'd planned to do so from the beginning. I wondered what he was up to, but he actually did us a favor in the end. I think the Ironheart excavation site is underneath that facility. A pretty hastily built structure? Check. Multiple security devices guarding the entrance? Check. Commander-level Vulgus disappearing inside? You can see how it all adds up, right?
I see you.
I need to assign missions to all operatives to shut down the facility's multiple security devices. It'll require specific procedures, but I've had experience in dismantling many of these types of devices. Let's move. We need to get in there before the Vulgus can do anything to the excavation site.
I have to admit, not even my arcade can penetrate the quantum barrier of these security devices. Those rust buckets have put some thought into this.
High-level Vulgus closing in. Prepare for engagement. device is disabled. Mission accomplished.
What am I supposed to be doing with this shit, guys?
I've received word that the supply box has arrived safely. The authentication sequence is as good as secured. Good job.
Reloading.
Power to the security system has been reduced. 2 generators remain. This is the last generator. Keep going, Lieutenant.
Concentrate defensive forces and power.
Hope that you fucking with me.
Send high-level firepower units.
We gonna aim shit on this nigga.
Must be stopped.
Driver shit.
Execute them.
Driver shit.
Power has been
Just driver shit and
deactivated.
shit.
Security system compromised. Tactical target achieved. Terminating mission relay.
He is me. Pull up on your block, banging out on windows. Oh no. Lately I've been smelling some fishy. Let me see you all on shit. Let me see you all on shit. Told him not to shoot the nigga, shoot the nigga. Fooling with him. What you doing with him? Stupid bitches. Social distance. Ain't no grown man come up missing. Lately I've been smelling some fishy. What's wrong with him, God? Get him out of here.
Bogus reinforcements detected. Internal facilities destroyed by Germany.
What's wrong with him, God? Good night. Good night. Good night. Good night. For sure. For sure.
Bogus reinforcements closing in.
For sure.
This is more than we expected. Without the
We don't
advanced
care.
attack to reduce their forces, we'd be surrounded by now.
Nah, I want that 3-shot burst. What's up with you? What's up with you? You ain't cool with me? What's up with you? Catch all of them.
Unit numbers critical.
Catch all of them.
Munitions. Urgent
Catch all of them.
requested.
Catch all of them. Catch him. What's wrong with him? I ain't see how he was coming. You smell me? I ain't see how he was coming. Nigga ran like that, guy? Get some of that, man. Let me get some of that, man. I like how the guns look when they go off. These should be having that flame to them. You know what I'm saying?
You're almost there, Descendant.
A word?
Keep out.
Nah. Nah. Cállate. Cállate.
Barracks unrecoverable.
Cállate.
Defense failed.
You've got it,
Cállate.
Descendant. Mission relay terminated.
Cállate. You know what that means? Cállate.
This is Sharon. All Vulgar security levels have been successfully
Cállate.
deactivated.
That's what that means. Cállate.
All
Shut
units
your mouth.
regroup at my position to investigate the Ironheart excavation
Cállate la
site.
boca.
Regroup? Huh. Yeah, I don't think so. I think I'll sit this one out, Sharon.
Esto que ándale,
What did you
ándale.
say?
Yeah, yeah. Oh my. I got 48 rounds though. We'll take that. I'm sorry. You got to go. You got to go. 31 out of 31. You got to go. You got to go. I apologize. You got to go. Lately, I've been smelling some fishy. I don't know what got into the nigga. He was running out of his mouth. Told him I had to shoot him. What you doing, lady? I've been stupid bitches. Cause can't no grown man come up missing. Boop, boom! Lately I've been smelling some fishy. I ain't never used it. I ain't never used it. I got a higher one up there now, so I'm probably gonna let it go. I don't know yet, but that one's God. God. I don't plan on using a sniper. What's this? A salty? I got. That's God. It's God. God. We just clearing it out. When I come through, clear it out. Clear the sideline and observe how a real nigga air it out. When I come through, clear it out. Play the sideline and observe how a real nigga air it out. When I come through, clear it out. Play the sideline and observe how a real nigga air it out. So they do what she said, okay, rápido. This money in my hand, I really want a rapid flow. And I talk about that money, I love it though. Let me tell you what I mean. That's a maca ring. I pull up on your block. I let that thing go ring. Let me tell you what I be doing things. I pull up on your block, I rearrange your face and things. Niggas been on my dick, I'm trying to give her a taste for things. I hit you with that macarena with that foreplay, you know the thing. I need whole guy. I need whole guy. Break up available. I didn't do it, you know. Oh, that's me, that's my own chateau. It's a green, but it don't got to. It's a green, but it don't got to. Something fell, something hit the floor. Probably now and I'm not children, no, no, no. They talking about the team, man. Yeah, man. I don't understand, man. I don't know him. You know, that's what I do, man. You know, that's what I do, man. I come to, you know, I pop top, you know. Shout out to the Watanos. My boy be tripping, moving around. He keep his man on the plantanos. Big gun on me. How you want to know? You be talking about it, but you don't got the pole. I keep my pole. Extensions. I keep the gold. You know him. That's who. That's HB. Yes. People flow. Am I supposed to get on there? What am I supposed to do here, bro? Take off my Mr. Bombastic. Fantastic. Yo. Just like Placenta. Oh me, oh my, well, can't you tell? Oh. They call me Mr. Bombastic. Fantastic. Thought I missed that road. Ooh, behind me. Somebody deserves somebody.
Reload.
Sure, black out. Go on, brother. Go on, man, brother. Go on. Hmm? No way to the door? Hmm? No way to the door? Hmm? Oh, you want me to go other way in the door? Hmm?
Get to the point.
You want me to get to the point, little pretty boy? Hmm?
It seems as if all of you have forgotten, so I'll repeat myself one more time, since they're here too. It looks like it'll be a guide-related mission from this point on, which means I can't have anything to do with it, right?
You don't know that? Hmm?
You're the one who told me I should be in a supporting role.
You didn't know what you were saying, huh?
Since I can't connect to the guide,
That's what you're getting, my man.
report that to HQ however you like. It's not like they have a cell. Oh, nah. Maybe I
Go
will
watch
sit
you
in
talk
a
about,
cell
boy.
and get some rest. It's been a while.
Go watch
Last
you
time I
talk
was
about,
there,
boy.
it was- I'm not sure who blabbed about. I guess that's just
I
my
don't
little
care
walk down memory
what you
lane.
speak on, man.
Have fun with your
I
imaginary
don't care.
friend. Peace.
Sharon,
I don't
give me
care
the order and I will track him.
what you speak on, man.
Jeremy's RK ability.
I don't care about the stories. Just let me shoot them.
With Jeremy. I have no knowledge of the
Yeah,
details
well,
of
go
these
on, man.
directives, nor am I capable of ignoring them. If I were able to alter those
They're trying to
directives,
figure out
would I have been able to
what
resolve
is
this
it you do?
misunderstanding with Jeremy? The human mind is
Is it
difficult
black?
to comprehend.
Is it Jamaica?
Feels like a mass of powerful energy
Is that
surrounded by a
Spain?
resilient defense mechanism.
Is it Dominican?
I apologize for all. I hope I
What
can
is it?
You'll need to leave first, Lieutenant.
Him all over the
Sharon's
place, man.
prosthesis has
That's
been
what he
damaged from
means.
excessive RK use.
That's
We'll
what he
join you
means.
as
Him
soon as we
all
can.
over the place, man.
Don't worry. You've seen what they're capable of.
Match me.
I hope these repairs can be done quickly.
Estimate wait time 26 taken, man. What going on with this team, man? What the fuck are they doing, man? I just feel like it should go faster, man. You know what I mean? I think I should clear all my stuff, man. 1 gun, 2 gun. Lots of stuff, man. Splash them out, man. Splash them out, man. What can you say, man? I did not know, man. All I want to do is pass off my letter to 22 All I want to do is buzz off my late 22. I had a job, but I keep
documented in the
high.
ancestors' data.
I got another
As you
in my
must know, the
bag.
Ironhearts
He
are
been
mysterious
hating on
entities
this
that
nigga
somehow made their way to
sad.
Ingress. They were first discovered by the
So I'm
Architect. The
alright.
Ironhearts were passed down to the ancestors, my creators, and the forebears of the descendants. We don't know why the ancestors hid all the Ironhearts. But this much is certain. I was created in order to lead you to them. After that,
Damn, blood.
we'll come to that once we find you an Ironheart.
Y'all left me. Y'all see my back, guys. I'm two Xbox players. I don't care. Because I'm on CPU, it's the same thing, man. What going on with the Rasta boy, man? Pop out. Face me like a man. Talk to me like a bitch. What the rascal going on there, man? I got the rubber band effect going on, man. I told you, chat, shoot him in the legs.
These are traces of
They pull out a shield, shoot him in the legs.
Ironheart microparticles confirmed. Initiating emergency restoration protocols to repair damage.
I don't care. Get him out of here.
We have retrieved
Oh, you are my bitch.
excavation site. Next, I must... Oh no. This wasn't just an excavation site. I need to interface with the quantum monolith, a data processor belonging to the ancestors. This device contains my restoration data, which can be copied using Ironheart microparticles. I can guide you there.
Recharged.
However, to access the quantum monolith descendant,
I got it, brother.
must undergo
Watch out,
authentication
man.
here first. I should still have access, as it was my system and memories that were damaged. Please keep the Vulgus at bay while the authentication is in progress.
I can't let you do that, brother. 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 I stand my ground. I don't give up.
Accessing core asset. Approaching high risk levels. Initiating facility lockdown procedures.
Descendant. Passage being blocked across the facility. I'll do my best to find a way out, but it won't be easy to maneuver. Please be careful. There must have been countless experiments conducted here using the Iron Hearts. Emergency restoration protocols would have been one of them.
Oh no! Damn it. The whole thing though, man. Why can't you just be like Destiny? Just make clear. I gotta start looking for that red dot, man. That's where I mess up at, man. I don't look at the red dot, I feel you. Granato. Resurrection eliminated. I'll rip one down. Take him out. Take him out. We're going up. Oh. I'm too sexy and I know it.
No one can leave! Executing Legion of Immortality General Amon's orders!
Amen. Descendant, I must access the quantum monolith. Defeat the Vulcus.
Adjusting distance.
I actually gotta go to this. I'll buy it from you. Are you ready to go to sleep? Well, as y'all heard, I go buy my daughter some juice. As you heard, shout out to my fucking gang. A squad in the fucking building.
The void corrosion has encroached upon my legion.
Fuck wrong with them.
That is because of an unknown error. It will be fixed momentarily.
That nigga up out of here, B.
Complete. The security threat has been neutralized.
Has it? I'm still here.
I have completed all preparations as you commanded.
Begin.
Don't begin. Wait. Hold on. Give me a second.
Legion will be reborn through the Iron Heart.
Rise, my warriors. Give your lives for Clipper.
Philippa? What? No one can hear me.
Stand at the vanguard for me, Al-Sharuk. I will stand at the vanguard of the Legion.
I'm only letting this finish and then I'm out of here, Joe.
Al-Sharuk
What we got?
submits
10 hours?
to Karel's command.
11.
Armor,
Come on now.
transport the Ironheart to my fortress.
That's more niggas doing at their day job. You hear me?
Initiate the data inversion immediately.
Make sure to support. Get that stream elements link in the chat. You donate there, you can donate to the Cash App. It's either way. A couple people hit me up today, said they wanted to donate. I said, hey, I ain't got the sub joint because I ain't affiliate. Not yet. And I don't know why. So you gotta get, what is it, fucking 5 consistent in the chat? Bro, hardest thing in the world for me. I can get 5 people in the chat, but they ain't all at the same time. You feel me? Why would I lie to y'all? Be the gang. Yo, but oh yeah, dang, we got it. Why do I think I forgot all this stuff again?
Descendant.
Yeah,
Even
child,
though
we
the
out here.
Vaults managed to access the data
Respectfully.
first, I have been able to restore one of my core functions through the emergency restoration protocol.
Matter of fact,
I am
I'm about to do
finally
something.
able to detect the Ironheart.
I'm about to show
Let
y'all
me
something.
explain this function and how
This
to
what I
utilize
need from y'all, chat. This what I need. That's what I need from the game. I need for the game to do this for me. Tomorrow, if you're on computer, why is it not showing? There we go. This is what I need from you tomorrow. I need for y'all to. Tomorrow, 5 o'clock. If you on computer, come tap in. Come tap in. Blazing. Come tap in. We live tomorrow, 5 o'clock. 5 o'clock. We in there. You know what I'm talking about? Tap in with us tomorrow. But yo, I'm headed out of here. You know what I'm saying? I appreciate y'all for tapping in this long, rocking with me, doing the damn thing. You know how we do it, man. It's 80315. You know we always lie. You know how I've been feeling. We always been a villain. On top of that shit, I'm crying and murdering. I'm talking about. But yeah, appreciate y'all, gang.